you can hear me. If you can hear me, if you can hear me. I need that thumbs up. And I also need you to hit that like button. I need you to hit that like button, please. I need you to do all them things so I can get this chat call out the way. I'm waiting. Thank you. Muchas gracias. All right. Let me see who was first. Queen, everybody was first. QE. Woo! Queen in the building. Queen in the building. Hey, Sonya Davis. Marietta Jones. And when I say queen, that is Queen Christie. Everybody knows that, right? Hey, Star Whispers in the building. Hey, Tanya. Welcome. I'm sorry to hear that. Our condolences go out to you. I'm very sorry to hear that. Lady G in the building. Lady G in the building. My Queen K is in the building. Jojo the Lion is in the building. He has put up on with his horse, honey. Oh, I had a dedication for JoJo. And damn. And JoJo noticed I don't know the words, baby. I don't know the words to the song. But, honey, to hear this dedication, let me see what them likes are. Y'all gonna have to like us up, baby. That ain't enough. Are you crazy? Are you on crack? You gonna have to like us up. Like us up if you glad you can see the goddamn thumbs up button. Like us up if you glad that you are able to like somebody up. Like us up if you are granted a goddamn 4-day weekend. Like us up because that's the right thing to do. I got some reading to do. Now, and shouts out to the person that shit, I'm scared to say that, honey. But anyway, so I'll say this. Shouts out to Sylvia because I heard her read the transcript. And of course she did her reenactments. Her reenactments. Yes, her reenactments, honey. So shouts out. I was sitting there, I was like, ooh, okay. That is cool beans. What's good with it? What's good with it? Yes. Now, I need me some more on the thumbs up button. Let me go right here and holler at y'all. Hey, T House. So listen. So let me explain this real quick. Now, y'all do know that being blue over here is a free membership. It's not, it's nothing else but a free membership, right? Well, but comes with perks, right? When we do play games and stuff like that, it'd be for the blue people and all that, right? As well as so the last thing we do over here is block, unless we just having a block party, we in a shitty kind of foul kind of mood, and we don't want to hear that shit. You know what I'm saying? But really, unless there's somebody talking about somebody's mom and kids and shit like that, yeah. As well as if you got those troll names with somebody's picture on it and stuff like that, we block those. No, there's no negotiation with that. Also what I just added, because it's dealing with the link, right? Funky ass link. If you are a blue person and it is a closed forum, like it is tonight, is a closed forum, you can go ahead and hit the link. You don't have to ask me for it. What I mean, well, I'll have it pinned up there. If it's a closed form, if you're a blue person, you can hit the link. If now, I have to go in and turn Sky and Jeff blue. So if y'all listening to this, Sky and Jeff, y'all know y'all blue. Y'all know y'all can automatically hit the link. If it is a, so, that's just what it is. All right. If it is a open form, you got to ask for the link. All right. That's, if you blue, again, you can click it. If it's an open form, you got to ask for it. That's just quite plain and simple. If anybody can remember those, I hope that's not too complicated. Um, I just think it should be that way. And I think the people that comes over all the time should have that exclusivity to the link, right? So yeah, I thought I got you. T House, I thought I got you. Hold on. Uh, yeah. Okay. All right. So let me speak to the rest of y'all that's coming on in the building. Hey, Angel 8, Ruth Wilson, millionaire. I think I got T House. So I said hey to her. Let me make sure all y'all. All right. So that's what's, what I'm saying. So now, if it is closed, of course, if y'all come over here all the time, you can ask for the link and I'll give it to you. But other than that, that's how we're going to do that. So now, like I said, Sylvia's already read this. I don't know how many people have heard that. I wanted to read it for you guys over here. And of course, I'm reading. I'm trying to see. I'm trying to get anything. I'm just trying to see like what the fuck happened. All right, what was said and what have you. Right? Because somebody told me that no one spoke on behalf of R. Kelly, and I'm like, I don't know why. I don't know if that was strategically done, because that could have been read into some type of remorse that may have been. You understand what I'm saying? So I can't believe that nobody would have, spoke up, for him. So that was probably done strategically. All right, especially if there were people there. And one thing you have to realize, right? So let me say this because I've heard, oh my gosh, I got so many questions, people saying, incorrect stuff. And honey, I can't correct all that stuff. So if you hear something and it don't sound quite right, ask them to verify that. And they should be able to go find it. I mean, if they talking about it, they should be able to back up what they're saying with something. Because if you ask me, I'm gonna tell you the truth. Okay, but I got a lot of questions. I mean, I haven't gotten all of them questions that's pending back there. And then I heard a whole bunch of incorrect stuff that with the process of the law, with the process of both cases and things that people thinking that people gonna be indicted in Chicago from New York and all that crazy stuff. Like, oh my gosh, no, these are two different jurisdictions. We already have an indictment in place, a superseding indictment. It couldn't be superseded, but doesn't mean that just because people that were in the case in New York that was there to, I mean, how crazy does this sound, right? If they were in the case there in New York that could have been indicted, why the fuck would they go to Chicago and why you think the Chicago is going to indict them? No, that's typically not how it works. And those people that spoke in Chicago, in New York, those people, they were speaking with in regards to a RICO, which means the bus drivers, the managers, all those people had to testify. Well, I'm not gonna say they was given an option to testify, but they testified there. That was in regards to a RICO. All of those people were needed to facilitate whatever the alleged crimes were. In Chicago, he doesn't have a RICO. He doesn't have a mention of managers, bus drivers, and all of that. They only have Daryl McDavid and Milton Brown. That's who they have. So that's who you expect to see. Unless they have some of those people coming just to testifying as to the day-to-day operations to fill out their evidence. But it's different because in New York, they were being somewhat accused of helping to facilitate his illegal activities, right? Is alleged illegal activities. Because that was the premise of a RICO, right? We don't have that in Chicago. We don't have that. We got some tapes, some people on the tapes, and a conspiracy to get tapes back. Now, you might see some people come there and say, well, maybe to corroborate like their position or whatever, if it has something to do with the tapes and what's going on in Chicago. So it's very important not to merge the two cases together. They are separate. Stop yelling incorrect shit. You're killing me. You're killing me dead. I can't tell people just to listen to me and pay y'all no mind. I can't do that. Or to go verify the shit yourself. I just can't tell people to do that because it make me sound like a domineering hater or some kind of stupid shit like that. And this YouTube shit ain't that serious for me. I saw one idiot sitting in another fool's chat talking about I'm gonna get indicted because some shit going on over here because I getting both sides for clicks and views. Are you stupid? I haven't had not one clout chasing moment. You don't see me running all around chasing the lawyers and the friends you don't see me doing that. I'm come behind this motherfucker. And even if I had chosen to support a side, and see, here's the operative word, supporter. I don't support nothing. Even if I did become a supporter of a side, I would still come out and do the same thing. That's it. It's not that serious. I'm not trying to be in Hollywood some motherfucking well. I have a completely separate online life that I'm completely happy with. They got shit to do with this. I'm not even in that particular vehicle. I'm not even on YouTube with that life. I still have my same YouTube life as I had before I even came on here. My online life. Yeah. So that is not my focus. None of that. I'm not here for no likes and views and nothing like that. Only thing I be asking for is a goddamn thumbs up button. And to make sure that as a people, we know what's going on with whatever side. Just the legal side. You have people that come out here to give their perspective, their psychological, I call it that, analyzation of some shit. You have people that come out here and do that. It's the same thing. And then you have people who are supporters, which are, I'll say 98 to 99% of you guys. That's not me. I don't have to either. I don't need all that. I am not starving to get for no fame and shit like that. So you'll never see me over here talking about people doing some shit, the same shit I'm doing. Like, I see people talking about clout chasing when they are the number one clout chaser on this motherfucker. I don't know how this works. And crazy as hell. Yeah, I said it. I told you, don't ever take shots at me because it ain't gonna work out for you. You should, you play and you got motherfuckers, and this is the type of shit I'm talking about right here. If you quote anything that comes from over here, make sure you quote it right. Or simply just play it. because you don't know what you're talking about, and somebody asks you a question about what you're talking about, you're gonna fuck it up. I'm not being big headed. That's not how I do, right? I'm just, if you moving the information along, move it correctly. Oh, come up with your own shit. Don't sit up here and plagiarize people's shit and then talk about them, take shots. Now, it ain't gonna work that way. Now, the next time I hear a motherfucker quoting anything from this motherfucker, I'm gonna put you on blast. I'm gonna attach your name to this very descriptive subliminal. Yeah. I told y'all to beat the nice girl out of me. I heard somebody quote JoJo's entire motherfucking spiel. I'm like, goddamn. Are you serious? Talking about Whitney Houston, Prince. I'm like, goddamn. You just should have just played the live. Goddamn. But people like to fraud you motherfuckers. They want to claim that they not frauding you motherfuckers, but they frauding you because they aren't coming up with their original shit. They sitting back taking motherfucking notes, probably as I speak now, to bring you some shit they don't even know what the fuck it is they talking about. Ask them one question, legal question, and see what they ask on right. See what you'll see. I'm like, oh, this motherfucker don't know what they talking about. Right. Because all you're doing is listening to what I say. You don't even understand what I'm saying. You just repeat it. But if you repeat it in a manner that, comes through your words, I'll know that you got it. Because if you knew it before I said it, you should have been said it. That's a checkmate. But this is all I'm talking to people that throw shots. I'm not a person that need credit and shit like that. I've gotten all of that in another life. I still get it in this life. This don't mean shit to me, okay? I just realized that we have, oh my gosh, the information, oh, people are still lost. Like, just the other night, I had explained on JoJo's channel, Keep Speaking, that it doesn't matter when Faith, it has nothing to do with when Faith got allegedly contracted some herpes. And as we went through the transcript, because I read that part of the transcript, well, none of that about she got no herpes in 2013. No, that wasn't it. But that has nothing to do with the charges. The charges had something to do with the exposure. So listen, y'all, listen. If you care about what you're talking about, or you want to know about what you're talking about, know if he's being treated unfairly, because if you're saying that those charges don't apply and whatever, then you need to know why they don't apply or why they do apply. And you have to read what he was charged with. And under each count are the elements in which the prosecutors must prove. If they don't prove those elements, then you have a good argument as to why, this was a wrongful conviction. It's not that hard. Okay? The Mann Act for Faith is that she crossed state lines, had what amounted to illegal sex because she was exposed to the herpes virus. I think in California and in New York. That was the extent of her Mann Act. It has nothing to do with whether she got the herpes. Even if she wouldn't have contracted herpes, it still would have been a charge because allegedly he has herpes, and you can't have sex with someone with an incurable disease and not tell them that you have that disease, by therefore not getting their consent to have sex with them. Okay, so everybody should understand that. Let me holler at some more people. Hey, Love's Fair. What's good with Hey Faye? Hey, piece in this puzzle. Hey, Leslie Jennings. Ooh, we got a new whisperer in the building, a new one. Ooh, she made whisperer status. Yes. Hey, stilettos for me. I think I got Ruth Wilson. Yes, yes, yes. And Angel H. I think I got it. So, and so for the most part, I think pretty much everybody was happy that Debo got the situation. I wish he would tone it down some because making me a nervous wreck. But that's Debo, and you know I've never taken sides in nobody's nothing, and that's not for me to do. And I don't get upset because somebody fuck with somebody that I don't fuck with. There's a lot of people go over there to that lady's chat. I don't get mad at that. That I'm supposedly be cool with or whatever. I mean, I don't give a fuck, but I'm just saying the different people that that are my enemy. I don't get into all of that. I'm not stupid like that. I'm not crazy and emotional like that. I don't. There's nobody that I have sworn to have a forever beef. I will forever not like you, but to have a forever beef, that's something different. I will forever not fuck with you. Yeah, I'll do that. But the going back and forth, nah, I'm not interested in that because that don't do nothing but run my pressure up. I want to see, I want to do something else other than back and forth and back and shit. Rah rah and who got the laws, rah rah and all that bullshit. Nah, you know. But if anything, when people paperwork comes out or they got charges or whatever, I just read them as if, because that's what I do. Read and see what the hell is going on. I do what's the pros and the cons, what's wrong and what's right. That's it. I'm not emotionally attached to none of it. Some people we have straight up sociopaths out here and psychopaths. They got issues. It's not my issue. I don't give a fuck. I say that with all sincerity. I don't give a fuck. And fuck your feelings. That goes for anybody. Fuck them. I don't ask you to feel, when I feel about certain shit. Don't expect me to feel how nobody. It's not. It's not. I'm talking about a whole bunch of situations out here. It's more than just Debo's situation going on out here. You know. So, but anyway, so with that being said, one thing, and this is good. It depends on what side you're on. What side you're on. When the judge blessed us with her ruling on that motion to acquit or motion for a new trial, she went ahead and justified her rulings and actually backed up her, with her factual or legal findings, right? Her legal analysis. What I mean by that is what I kind of told y'all before. She gave us a glimpse on the chances of that stuff being granted on the appeals level. She did so. J-Bo kind of sampled to see, what would be the the results, the responses to the issues that she brought up. So now she knows she either have to adjust it or get some new shit. Because That judge, she pulled from mandatory law and primary law and case law. She backed it up. And then when you start seeing y'all hear the fireworks, Lord have mercy. They got the cannons tonight, honey. She brought backed it up with the constitutional references and procedural references as well as case law references. That's going to be hard to overcome. It's going to be very hard to overcome. Something else I want to talk about. So I want to talk about just a little bit before I go to reading because it's a lot of reading. So in reference to those grievances that Levi filed, right? Now, because I heard some talk on them today. The bar to from what he says right now, and so and I don't know the entire his points in its entirety, but I know he has some points with the ineffective assistance of counsel, and then he also has some points with um, prosecutorial misconduct, right? The ineffective assistance of counsel, that bar is going to be high to prove, with what he asserted, and plus you got to also prove it. And then the prosecutorial misconduct, if there is any there, for as did they suppress anything, did they whatever, did they turn a blind eye to allow stuff to go on, that's going to be you're going to have to prove that. Now if it's founded, then I mean that's almost a given, right? Depending on what it is. But yet you're gonna have to be able to prove that. So that's something. I'm not sure. Will that? And what I'm saying is, because I know he always says he's not moving off of the New York trial yet because of those matters, right? That he still have out. Well, I don't know. I don't know about if that would make a difference at this. Well, I mean, it got to be you got to overcome those bars. You got to overcome those bars, and I'm not sure how that's going to work to where it will actually someone at a later date making a judgment will say that because of these issues the ruling might have been different. Because remember, they convict you on the elements. That's the only way that's this in the jury charge. That's in every jury charge in every court. The judge may deliver it different, but you got to convict on those elements. And that's the only way you can convict somebody is on those elements. And to prove someone ineffective, a counsel that's ineffective, just simply not filing motions and on a time basis, that does not constitute. I went through all of that on a whole bunch of lives. So I mean, I can go back and try to reference, try to find it or whatever. I'm gonna try to get better with titling it a little better so you can go back to see the different areas I've already covered, and then you could reference it yourself. But it's kind of hard. I'm just being honest. Also, J-Bo, right? Now let's get something clear. Because I heard this today, too. I was listening. J-Bo, the motions that J-Bo is filing are motions that can only be filed post-conviction. So these, just because you see her filing motions now, she's filing because they are post-conviction motions. The pre-trial motions were supposed to be filed pre-trial, and then the ones that could be filed during the trial. But other than that, that's just what it is. So you can't say that she's doing a better job than the team that handled the trial, because again, I stress that this whole process is broken down in clusters. You got your pre-trial, you got your trial, then you got your post-conviction or post-trial, right? That's three different areas right there. Right now, let's see. If something comes up in enough time, you might be able to file a motion to resentence, maybe, or to modify. After the appeal, they are going to do a motion to set aside, vacate, or motion to set aside, I'm sorry, or vacate, right? So, and that's the 2255. That's after the appeals, right? So again, with New York, there's still some levels to go. I just want to make sure you guys understand that. So with that being said, let me go ahead and get on this reading. So, and the bond record, they always, just about every time they put in a motion, most lawyers always include a bond request. That is pretty much customary. Okay, that's just pretty much customary. There are some things that, like I said, there are motions that are supposed to be filed post-trial, pre-trial. We in the post, and I keep stressing this, but you're gonna have to deal with the post-conviction phase of it. You can't skirt around it, and please stop giving incorrect information about it. I keep getting caught because I've been to say one thing, they go list somebody else who is, pretty much credible as well, and then they're asking me, I'm like, oh Lord, uh-uh, uh-uh, shit, that ain't it. So now, like I said, I discovered, this is just my opinion, that judge, when she answered that motion for a new trial and for acquittal, that she pretty much justified all her rulings, and she gave some, did a whole bunch of fact finding and a legal analysis, right? That protects her for an appeal. So it makes it harder. Because see, all of that's going up on appeal. It makes it harder, right? And when you go on appeal, the only way you can get additional time, if you say you get appeal granted, if when they have a new trial, you could just say your appeal gets granted. They say but they want you to have a new trial. You go and do a new trial, then they give you more time. And you have to explain all these things. If not, people will be confused. So let me go ahead and start here, right? This is from June 29th. This is the sentencing hearing. And I'll start with the courtroom deputy. It says, all rise. The judge says, good morning. Everybody can sit down. And the deputy says, this is a criminal cause for sentencing. Docket number 19 CR 286, United States versus R. Kelly. Counsel, state your appearances. The government first. Ms. Geddes, good morning, Your Honor. For the United States, Elizabeth Geddes. Nadia Shahada and Maria Cruz Melendez, good morning. And Donnelly says, good morning. Ms. Geddes says, also seated at counsel table is Special Agent Ryan Chabot, the Department of Homeland Security Investigations, and Frank Nicolatis and Patricia Sullivan with the Probation Department. Ms. Sullivan says, good morning, Your Honor. Mr. Nicolatis says, good morning, Your Honor. The judge says, good morning, everyone. And Jabo says, good morning, Your Honor. Jabo and Ashley Cohen. Cohen, on behalf of the defendant, Mr. Kelly, who is also present here today before the court. The judge says, good morning. And R. Kelly said, good morning. I wish that you would give me a sentence less than 30 years, like 3 years, so I can get the fuck out of here. That'll be time, sir. And the judge says, all right, we're here today for a sentence after trial. I just want to go through a couple of preliminary matters. I'm just going to remind everybody here today, and I think our courtroom deputy has already made it clear, but there is to be no talking, no reaction of any kind, and our court security officers will remove anybody who does that. I am certain that is not going to happen, but I just want to make sure everybody is aware of that. I'm sure the parties are aware, but I have denied the defendant's motions for acquittal and for a new trial in their entirety in an order that was filed late last night. Throughout the proceeding today, I will be referring to victims or witnesses using the names that were used at trial. I just want to remind the parties that those are the names we will use to refer to them during trial. And then, just in terms of this order, obviously, the first part of today's proceeding will involve going through an analysis in the application of the appropriate sentencing guidelines. Given the complexity of those, that might take a little bit. I anticipate that we will break after that. And I just want to check with the government. Pursuant to the CVRA, I understand it is 7. Ms. Geddes says that is correct, Your Honor. The court says 7. Ms. Geddes says correct. And judge says okay. And just in terms of the order of that, I anticipate, that will be after the guidelines analysis. Is that correct? Ms. Geddes says aye. The judge says, well, it is before the parties. Usually the order is I'll hear from the defense counsel, then from the government, and then from Mr. Kelly. But I think the statements of the victims will go before all of that. And usually it's the prosecutors that go first, but a judge can, direct her own court, however she wants to go. Ms. Geddes said, I agree. And the judge says, okay. Geddes says, thank you, Judge. All right. So with that, let's proceed. All right. Mr. Kelly was convicted after an approximately 6-week jury trial of all 9 counts in the third superseding indictment, racketeering in violation of 18 U.S.C. 1962C. That's count 1. Count 2 was coercion for the purpose of illegal sexual activity in violation of 18 U.S.C. Section 2422A. I'm also, just for this very reason, if you have a phone, turn it off because it's distracting. And those are for the people who are permitted to have phones. So that was count 2. Count 3 is in violation of 18 U.S.C. Section 2422A. I'm sorry, that's count 3. Count 4 was another violation. was another violation of 18 U.S.C. Section 2422B. Count 5, 2018 U.S.C. Section 2423A. Count 6, 18 U.S.C. 2421A. Count 7, 18 U.S.C. 2422A. Count 8, Section 2421A. And count 9, 2422A, 18 U.S.C. Section 2422A. I will not go through the racketeering acts except to say that the jury concluded that the government had proved all of the racketeering acts except for counts or acts 3 and 4 within count 1. All right? I'm going to go over the documents that I have reviewed in connection with today's proceeding. And if there are quite a few of them. If I have missed something, the parties will let me know. All right? Obviously, I preside over the trial, but I also reviewed in detail the trial transcript, the pre-sentence investigation report, as well as the probation department sentencing recommendation, which I think both sides have. Is that correct? Miss? Yes. J-Bo says, yes, Your Honor. The judge says, okay. All right. The government filed objections to pre-sentence report on April 19th. The defense filed objections on April 20th. The government responded to the defendant's objections on May 12th. There was an addendum to the pre-sentence investigation report filed on May 24th. The defendant filed the first part of a sentencing memorandum on May 27th. The government filed some additional objections to the addendum to the pre-sentence investigation report on June 3rd, and then the government filed its sentencing addendum on June 8th. There was another addendum to the pre-sentence investigation report filed on June 13th, and then also on that day, the defense filed a supplemental sentencing memorandum with exhibits that included reports prepared by Dr. Patrick Dietz and Ryan Salisbury, and then the submission also included letters from Mr. Kelly's supporters. The government submitted on June 17th a letter regarding restitution. On June 23rd, the government replied to the supplemental submission. Then there was a third addendum to the pre-sentence investigation report filed on the 24th. The government filed this letter pursuant to the Crime Victims' Rights Act on June 24th. The defendant replied to the restitution letter that the government filed on June 27th. To the extent that some of these submissions were under seal, I think that was the defense supplemental sentencing memorandum plus exhibits. I directed that those be filed with some redactions on the public docket, and I believe they were. Is that correct? That is right, Your Honor. Okay. The government's letter regarding restitution, as well as the defendant's response, was filed under seal and remains sealed. Okay? All right. Is there anything else that I have forgotten to mention? No, Your Honor. For the defense? No, Your Honor. Okay. And Ms. Bonjean, have you and Mr. Kelly reviewed the pre-sentence report? We have, Your Honor. Okay. All right. Now, I don't understand any side to be requesting an evidentiary hearing. Is that correct? The government is not. Thank you. That is correct. We are not. Okay. All right. At this point, I am going to go through the sentencing guidelines calculation. As I said, there are not only a number of counts which require some detailed analysis. There's also a significant level of disagreement about the extent to which some of these enhancements apply. I have read the voluminous submission on this topic. I don't need any further argument on it. I will say that both sides submitted very thorough arguments in support of their position, and the probation report itself is quite thorough. So what I'm going to do is just go through what those particular issues are with respect to each count, lay out in sort of general terms what the objections are. To the extent that there are objections, they are they are all preserved because they were in your submission. But that is the way I plan to do it. And when she said they were preserved, meaning that they were preserved for the appeal. All right, because they are objections. So you preserve those on the record for the appeals. All right, she says, I will start with count one, which is racketeering act. The racketeering count, and within that, the first racketeering act is bribery. This is in connection with the Leah. There is at least between the parties, there's an agreement that the base level offense level is 12, and that's the adjusted total. Probation added a 2-point adjustment pursuant to guideline 3B1.4, which the government does not advocate for. Excuse me, y'all. That has to do with directing or soliciting a minor in connection with the commission of the crime. But the parties agree that that doesn't apply under the facts of this case. All right, remember when I put up my pre-sentencing tool, and when they give you extra points when you are said to use a minor to help you commit a crime. Sorry, y'all. Probation also added 4 points pursuant to guideline 3B1.1A. That is for the defendant's aggravated role. The Second Circuit has endorsed an approach that this role adjournment is to be made on the basis of the defendant's role and that overall a racketeering enterprise, rather than on the conduct that's in the underlying predicate acts. So I find that the 4-level role enhancement is warranted, but it's going to apply to count one as a whole, not to each individual predicate act. Okay, well, that was a good thing. Moving on to Racketeering Act 2, under count one, that is sexual exploitation of a child, and the victim is Stephanie. There is a base offense level of 32. The government and probation agree that an additional 2-point enhancement should apply if the offense involved the commission of a sexual act or sexual contact. The defense objects to this on the ground that the enhancement is duplicative of the sexual conduct part of underlying base offense. Hold on, y'all, let me stop sharing this. I think the government and probation have the better argument here. The statute prohibits a defendant from engaging in sexually explicit conduct, which does not necessarily involve a sexual act. It doesn't involve actual sexual contact, and that's a significant difference. Also, and so I find that that enhancement applies and that the adjusted total for that racketeering act is 34. Racketeering Acts 3 and 4 under count 1 apply to the victim Sonia. These were acts that the jury found were not proved. The government is not asking me to consider these acts for purposes of calculating the guidelines, and I'm not going to. But it is appropriate to include it in the pre-sentencing report because it is relevant evidence of the existence of the enterprise as well as its means and methods. And so it is properly included in the pre-sentence report, although it doesn't affect the guideline calculations. Just one point about Racketeering Acts 5 and 6 and 7, and that has to do with the question of whether those acts should be grouped pursuant to Section 3D1.2 of the guidelines. That provides that counts that involve substantially the same harm should be grouped together into a single group, and counts involve the same harm for purposes of this rule if they involve the same victim or transaction, or if there is the same victim and 2 or more acts of transactions that are connected by a common criminal objective, or if they are part of a common scheme or plan. So remember, I went through that and I was like, she didn't group these right. According to the application notes, the court should apply Should group counts when what they represent is a single injury or part of a single criminal episode involving the same victim. But the application notes, specifically number 4, specifically say that this section does not authorize grouping offenses that cannot be considered to represent essentially one composite harm. So the example that they give is the robbery of the same victim on different occasions. And those types of crimes would not be grouped because even though they're the same victim, there are multiple separate instances of fear and a risk of harm. It is not one composite harm. The acts at issue here, which are Acts 5, 6, and 7, relate to the Mann Act offense against Geronda, the forced labor of Geronda, and the sexual exploitation of Geronda. While these acts involve the same victim, they also involve multiple separate instances of fear and risk of harm and are not one composite harm within the meaning of the guidelines. Although there are some common criminal objectives that tie these acts together, and those would include fulfilling the defendant's sexual desires at the expense of minor victims. I conclude that grouping these acts would misstate the character of the offense and the distinct harms that each of those cause to the victim. So those will not be grouped. Calculating the total for Racketeering Act number 5, there's a base offense level of 24. There's a dispute between defendant on one hand and the government and the probation on the other hand about whether an enhancement pursuant to 2G1.3b2 should apply. That enhancement is for unduly influencing a minor to engage in prohibited sexual conduct. The defendant takes the position that is duplicative of the act, of the elements of Racketeering Act 5. As application notes provide, there is re, rebutable presumption of undue influence when a defendant is at least 10 years older than the minor victim. In this instance, Mr. Kelly was about 26 years older than Geronda, and there has not been rebuted, but it, in my view, the presumption of undue influence. The application notes instruct the court that it should closely consider the facts the case to determine whether the defendant's influence over the minor compromised the minor's behavior, the voluntariness of the minor's behavior, and the voluntariness may be compromised without prohibited sexual conduct occurring. The record here establishes not only that Mr. Kelly was far older than Geronda, but that he used his position as a celebrity to lure Geronda and maintain undue influence over her, as the evidence showed at trial, by implementing strict rules and that he expected her to obey. So I find for those reasons that the enhancement is warranted. There's also a dispute between the defendant and the government and probation about whether or not the enhancement pursuant to 2G1.3b3 should apply. This offense, this enhancement is applied when the offense involved has the use of a computer or cell phone to persuade, induce, entice, coerce, or facilitate the minor's travel. The defendant objects to this on the grounds that no such device was used. The evidence at trial establishes otherwise, that there was a cell phone communication between Mr. Kelly and Geronda, including for the purposes of arranging for her to travel to his house and to arrange other meetings. So that enhancement was justified. There is also an enhancement for sexual that the offense involved a sexual act or sexual contact. I have already discussed why that applies in another context. It is over the defendant's objection, but it is not duplicative in my judgment, and so that enhancement applies. That leaves the adjusted a total of 30 for Racketeering Act 5. There's an agreement between, let me make sure I understand it. I think both the defendant and the government agreed that this is 22. Ms. Geddes says for Racketeering Act 6. Judge says for Racketeering Act 6, yes. All right. Since we have plenty of other things to talk about. I am not going to go into reasons why that is appropriate, but suffice it to say that there is agreement on that one. Racketeering Act 7 is sexual exploitation of a child. Geronda, base offense level of 32. The government is not seeking an additional 2 points for the use of physical force, but the government is seeking the enhancement for using a cell phone or computer. As explained before, I think the enhancement is appropriately applied. Oh, I misstated what? I left out one 2 point enhancement. The government is not seeking the physical force, but it is seeking the additional 2 point for a sexual act or sexual contact, which is appropriate. So that's 2 points for that. It's 2 points for the cell phone, which leads to an adjusted total for racketeering Act 7 of 36. All right. Do I have the government's position right? Miss Geddes. Yes, Your Honor. The judge. And I know the defense objects to that. Miss Bongine. Correct. And the judge says, all right. Okay. Moving on to Racketeering Act 8. That is under count 1. That is the Mann Act for Jane. The parties are in agreement that the appropriate guideline is 2G1.1 with the base offense of level 14. I think that is appropriate. The disagreement here is between the defense and the government about the 4-level enhancement based on a fraud, and that is pursuant to 2G1.1B1. The factual basis for that enhancement is the fact that the government or that the defendant did not disclose the fact that he had herpes and that he had unprotected sex with Jane without disclosing his illness, and that Jane continued to have unprotected sex with him without knowing about that diagnosis. Remember, so that I just explained to you what that is the crime, not that it was given to anybody. That's the crime, the exposure. Okay, under these circumstances, I find that this enhancement is appropriate given the circumstances of the case and that it involved fraud within the meaning of the guidelines. So I apply the additional enhancement, which brings an adjusted total of 18. Just before I address Acts 9 and 10, the same issue comes up as to whether those should be grouped. For the basic, the same reasons that I discussed in connection earlier, I find that they should not be grouped. These are separate harms to Jane over the course of a period of time and involve separate instances of fear and risk of harm rather than one composite harm, so they will not be grouped. I will say, however, that I don't think anybody is disputing that counts 2, 3, 4, and 5 should be grouped with Racketeering Act 9, and that counts 6 and 7 should be grouped with Racketeering Act 12, and counts 8 and 9 should be grouped with Racketeering Act 14. Do I have that right? Prosecution said that's correct. The judge says defense. Jabo says correct, Your Honor. The judge says, okay, so on to the Racketeering Act 9, which is the Mann Act, the guideline on which the government is pursuing that the base offense level is 24. I note that probation had placed it at 32, but the government is not pressing this, and I'm not. And I think that's correct. Let me take another drink, y'all, real quick. Sorry. There's an additional 2 point enhancement under that the defendant disputes, but the government and the probation agrees that should be applied. This is pursuant to guidelines 2G1.3B1B, and this enhancement applies when the minor was otherwise in custody, care, or supervisory control of the defendant. And the facts underlining this particular question are that Jane's parents entrusted her to the defendant's supervision, authorizing one of the other, I'll say victim's mother, to serve as her guardian until Jane turned 18. And then Jane testified that she lived with the defendant in Chicago after that. The defendant's objection is essentially it is a factual one. But even if it were, well, the objection is that Jane's parents consented, which is really not the point of this enhancement. The fact that whether it's true or not, whether the parents consented does not change the applicability of this enhancement because it's directed not at the parents, but it's directed at the victim. The application notes also provide that this enhancement is intended to have broad application. I find under these circumstances that the enhancement is appropriate. There's an additional 2-point enhancement that we discussed. Oh, yeah. Also, I heard today, I'm sorry, y'all, that the judge didn't allow them fucking text messages or that she threw them out or whatever. No, they were never submitted at trial. The text messages that J-Bo brought up, they were never submitted at trial. The judge didn't rule on those during the trial. And if anybody would have done the judge's part, not just the paperwork drop from the prosecution and the defense, if you would have tackled the judge's entries, then you would have known that. Oh, you just listen, to what we were saying. And I think the only one that tackled that was Sylvia and I. So let's see. Okay, so there's an additional 2-point enhancement that we discussed previously about which it is applied when the defendant unduly influenced a minor, and that's the enhancement where there's a presumption when the defendant is at least 10 years older. For the same reasons discussed earlier, this enhancement is appropriate. The defendant was 48 and Jane was 17, and there's an additional coercion and force that was described at trial. So this is appropriately applied. I believe the government agrees for this particular racketeering act that the 2-point computer enhancement does not apply. It is not on your chart. But I think your submission says that it does not apply. Is that correct? And the prosecution said, yes, Your Honor. The judge says, okay, all right. And then finally, there is a 2-point enhancement for the sexual act or sexual contact aspect. I have already explained why that is applicable. So that brings us to a guideline of 30, of an adjusted total of 30. Racketeering Act 10 is sexual exploitation of Jane, a child. The base offense level is 32. The enhancement for being in custody, care, and supervisory control of 2 points is appropriate, as I've already explained. In this particular Racketeering Act, the enhancement for using a computer or interactive computer service or device is appropriate given the use of the cell phone. The 2-point enhancement for sexual contact is also appropriate, as I've explained previously. The government is not pressing the additional 4-point enhancement because the conduct at issue. This is for material that portrays sadistic or masochistic conduct. The government agrees that there was no evidence of this while Jane was under 18. Do I have that right? Prosecutor says yes. The judge says okay. All right. So adding those 3 2-point enhancement bring an adjusted total of 38. I'm pretty sure this is right for Racketeering Act 11, forced labor for Jane. There's no dispute that the adjusted total is 22. Is that right? Prosecution says that's correct. And judge says, all right. J-Bo says, that's correct, Your Honor. And judge says, okay. Now, Racketeering Act 12, which is also counts 1, 6, and 7. There's a base level of 14, and the point of dispute here is whether or not that fraud enhancement of 4 points applies. I conclude that this applies for the same reason that it applied in the same type of offense involving Jane, because the defendant did not inform Faith that he had herpes before inducing her to come to New York, at which time she had sex with him. That gives an adjusted total of 18. Racketeering Act 13 is forced labor with faith. There's a base offense level of 32, pursuant to Guideline 2H4.1B4. If there is another felony offense committed in connection with forced labor, the base level becomes, well, if it's aggravated sexual abuse, the base level is 30, with an additional 2 points if it involved another felony offense. I just want to make sure that I have the government's position right. The facts at issue are that the testimony at trial established the defendant obtained oral sex from Faith by means of an implied threat of force, and this has to do with a weapon, among other things. Is that correct? Prosecution said yes, that is correct, as well as fear. The judge says as well as fear, and I think she testified to that. It's the government's position that this is a violation of California Penal Law Section 518, and so it is constitutes any other felony offense under federal, state, or local law. I think under the circumstances of this case, the guideline enhancement is appropriately applied, which gives an adjusted total of 32. The last racketeering act is also counts 1, 8, and 9. I'm sorry, it's Racketeering Act 14, but it's counts 1, 8, and 9. There is a base offense level of 14. The defendant objects to the government's application to apply the fraud enhancement for the reasons that I have already stated. I think that it is appropriate and that provides an adjusted total of 18. All right. Now, turning to the multi-count analysis. Pursuant to Guideline Section 3D1.48, B and C, one unit is assigned to the group with the highest offense level, and an additional unit is assigned for each group that is equally serious or from 1 to 4 levels less serious. And then a half unit is assigned to any group that is 5 to 8 levels less serious than the highest offense level. So remember, y'all, that's when I was going by what J-Bo was doing, was giving a point to the highest levels. And that's when it went from 32 to 35 on J-Bo's calculation. Let me come right here and see how y'all doing. Wait a minute. Y'all still straight? Y'all good? Let me see. Hey, Michelle, that's all. Hey, Red Bunny. Hey, Red. McDonald. Lavelle Marshall, what's good with it? How's it? Listen, let me know how that chair work. You got to email me a picture so I can see which one you got. Hey, Fresh ain't dead. Yeah, happy 4th to everybody. Hey, Karen J, what's good with it? What's with the building? Hey, Angel H. I think I got you earlier. Okay, let me get back to it. Hey, Purple. Oh, well, this is why I F with you. I don't know what JoJo got going. JoJo always got some shit going. I'm trying to tell you. Oh, child, honey, that's a handful. You know what I'm talking about? That's a handful. I told him, I said, you're going to have to get 2 more women, honey, because you too much for me. Oh, shit. All right, let's go. Let's see. There's a table. Well, you know what? Give me 1 minute. I got to get my nostrils straight, as you can hear it. Hold on. Sorry, y'all. Yo, you had one the link. I don't care about you. Somebody, y'all come up here and sit with me while I read this. I don't care. Let me put this stuff, child. Jojo got me with so many goddamn remedies. Goddamn Vicks vapor rub all on my damn nose. Uh I'm congested. I'm having girl, we didn't do nothing but sleep all day. We was taking shifts, snoring. It was crazy. It was. But thank you, Queen everybody. You know, I really fucks with y'all. I really like y'all. I really do. Cause you know what? I'm only in life. I tell people I have the best friends and the best goddamn family members. And I'm only gonna fuck with the best people on YouTube. I don't give a fuck. Somehow the way I'm gonna figure that out. I'm gonna have a formula fucking with the best people on YouTube. Well, let me get back to it. I'm fine though. Child, we slept all goddamn day. Oh, allergy surgery, child. I bet I have no goddamn allergies. Let me see. Okay. All right. There's a table in the guidelines that provide how many points are added to the total offense level depending on how many units there are. I have concluded that based on my analysis that there there are 4.5 units. Basically, doing the math from these racketeering acts and from the separate counts, the greatest of the adjusted offense level is 38. So the 4.5 units applying that table means that that you add an additional 4. As I said at the beginning, I also add the aggravated role adjustment of 4 points pursuant to 3B1.1a. That yields a combined adjusted offense level of 46. According to Part A of Chapter 4 of the Sentencing Guidelines, in the rare case, if the for purposes here, if a number higher than 43 results from the application of the guidelines, the offense level is treated as an offense level of 43. So applying that analysis, the total offense level here is 43. There are, in addition to the calculation of the guidelines, the parties raised various objections to some of the contents of the pre-sentence report. Probation incorporated many of the objections in the first addendum and then the second addendum, and I'm just going to review the objections that are outstanding. Think I have already, and again, there has been copious briefings on this, so I don't know that anything more needs to be said about it. The defendant objected. I think I referred to this before. That's because the jury found that Racketeering Acts 3 and 4 were not proved, that it is not properly included in the pre-sentence report. Obviously, the standard here is preponderance of the evidence rather than proof beyond reasonable doubt, which was okay. Let me just to finish that point. I am not taking in account Racketeering Acts 3 and 4 for the guidelines, but I do conclude that the testimony was relevant and corroborated by other testimony, so it is appropriately included in that pre-sentence report. I should have started with the criminal history objection. None of this really matters for the purpose of Mr. Kelly's criminal history score, but the point of objection is contained in paragraph 227 of the report, which assigns a point for simple battery, which is a misdemeanor from 96. There doesn't seem to be any evidence of disposition in that case. So I think it's appropriate to remove that. I don't know if anybody has anything to say about that. Prosecution says no, Your Honor. Jabo says no, Your Honor. And judge says all right. And so just to conclude, so that still leaves Mr. Kelly with the criminal history category of 1. Oh, okay. Sorry. What's good with it?
Still learning.
Oh, look at you. You ain't got your black and white going. You just pushing buttons, honey.
Man, it's all about my bro back there.
I see your collage.
Straight
you
up.
gonna go on mute?
Yeah, I go on mute.
Okay. Hold on. Let me see if I can put you. I want to see the collage better. Let me see which button to push. Hold on. That ain't it. That ain't it. Oh well, that's what I have. Okay. Okay.
Like I say, it is what it is. When you get back to reading, I'm going on mute. You know what I'm saying? Straight up.
Okay. Oh, those ain't the pictures.
Nah, they ain't ready for that. It's coming.
Oh, okay. All right. I was getting excited. I'm sorry. All right. Then I'm gonna go back to reading.
All right, that's what's up.
Okay. And I should have said this before, that the total offense level is 43. And with the criminal history category of 1, the applicable guideline range is life imprisonment. The court Okay, now there were some other objections by the defense to the characterizations in the pre-sentence report, which were based on the testimony at trial. And for example, if there is an objection to the description of the enterprise and the characterization of the employees as members of the enterprise, this is something that is addressed in my decision on the defendant's post-trial motions, but these are appropriate characterizations based on the evidence. There is an objection by the defense to paragraphs 17 and 18, and the defense objection is suggesting, I guess, that the PSR says that the employees knew that the victims were minors. I do not think the PSR actually says that. Who said that? The defense. I mean, it says that the defendant inner circle selected women minors to join him backstage and after parties. There is a factual foundation for this information, which was the trial evidence, so that objection is overruled. Similar, there is an objection about the characterization of the defendant's rules and that his enterprise aided and abetted him in certain crimes. There is a factual basis for these assertions in the trial record. A number of witnesses testified about the rules that the defendant required the victims to follow, as well as the punishment he exacted with when they broke them. There is also record support for the aiding and abetting. The thing that leaps to mind most obviously is the bribery conduct, which is the subject of Racketeering Act 1. There are also objections related to Aaliyah. The defendant objects to the assertion that he had a role in the title of Aaliyah's album, Age Ain't Nothing But a Number. He says that is not so. He also objects to the assertion that he began sexually abusing Aaliyah in 1992 or 93, as well as the assertion that Demetrius Smith, in connection with the bribery count, told the defendant that he could obtain a fake ID if he bribed a public official. There is a factual basis for each of these assertions. First, the testimony at trial, as I understand it, was that the defendant wrote and produced the album, and apparently the album jacket says that he wrote all of the songs, which includes the title track. With respect to the sexual abuse, there is also record evidence for that, particularly the testimony of Angela, who actually saw the defendant performing a sex act on Aaliyah in 1992 or 93. There was also sufficient evidence to establish that Demetrius Smith talked about the bribery with the defendant in the record. The defendant was with the group when they went to get the fake ID, and after all, it was the defendant's interest that was at issue here. And there is also evidence of conversations. So that is appropriately contained in the pre-sentence report. The next objection is to the information that pending charges against the defendant, and they are just informational. There is no suggestion of any that the defendant is guilty in those, so that stays in. Excuse me. I think there is also an objection to other arrests. I think the arrest can be removed. It has no bearing on the sentence that will be imposed. Finally, I think this is the last objection. There's an objection to a sentence in paragraph 255 that reads as follows. Notably, Miss Savage was referenced above in the offense conduct section of this report, alongside many of the defendant's female partners who endured manipulation and abuse by the defendant for months and years' time. This is not an this is an accurate statement. I'm sorry. It does not say that she is a victim of the defendant. It just points out that her name is in the offense conduct. So that will stay in the pre-sentence report. I believe I have addressed everybody's objections. Prosecution, Your Honor, go ahead. Miss Bungine, no. The prosecution said the government also had a objection to the defendant's ability to pay a fine. The probation report currently states that the defendant does not have an ability to pay a fine. The judge says I was going to actually address that in the fine portion, and the prosecution said that's fine. The judge says I think suffice it to say that it sounds like there is still some investigation to be done to an extent of his financial situation. Prosecution said, and if this is an appropriate time, I did want to provide some additional information that the government has learned in connection with that. Judge says, have you provided it to Miss Von Jean? The prosecution says, yes. Judge says, okay, I guess now is a good time as any. Prosecution says, so it's the government's understanding that there are two separate intellectual property rights that stem from in the music world. There's the copyright that is from the actual words and lyrics, which is called the performing arts copyright. And there's a copyright associated with the recording itself, the sound recording, which is like the masters. And in the probation report, the probation department, I think, accurately explains the copyrights associated with the sound recordings, the masters, and that's in the hands of going to Sony, and that Sony is currently retaining those royalties as it determines how to settle some outstanding default judgments against the defendant. Separately, however, the defendant until August of 2021 was regularly receiving royalties associated with the second copyright, the performing arts copyright. Those not held up by Sony. Those were being awarded to an entity that was created by the defendant's close friend, Keith Calvert, one of the individuals who submitted a letter on the defendant's behalf. In August 2001, the government understands that the defendant sold those rights to a third party for 5 million. The government's position is that the defendant has not received that money pursuant to the contract, and we provide a copy of that to the defendant, but he's entitled to receive it, and with the combination of the money that the defendant will receive from Sony as well as that 5 million, that the defendant is in a position to, at least in the future, to pay a fine. Therefore, we think that the PSR should reflect the defendant's ability to pay a fine. The judge says, all right, Ms. Bonjean, what do you have to say about that, if anything? I mean, I'm not making a decision at this moment, but I will hear what you have to say about it. Jabo says, sure. Thank you, Your Honor. We did receive that document yesterday, and I have not seen it before. But I will say that as an officer of the court, my understanding is that any monies that he is entitled to through royalties, whatever bucket you want to put them in, are being held by Sony, and that there are liens or judgments against them that far exceed what he is entitled to. Now, I'm happy to explore it further to ensure that I'm making an accurate representation to the court. I think there was a time period at and around the time of the trial where he was still receiving some royalty income, and some that were working their way through the Illinois courts. But since that period of time, my understanding is that has dried up almost entirely. That may be in part because of use, but also because he just does not have access to it. I would be happy to explore it further, but I am not familiar with him being able to get 5 million. I can represent that. The judge says, okay, well, it is something to bear in mind. It sounds to me as though there is still some additional work to be done in determining if there are other sources of income. Is that correct? Prosecution said, well, I don't think so, Your Honor. I think that I think it was the second addendum to the PSR that Sony has retained, if I added it up correctly, about $3.5 to $4.5 million in royalties. That is solely with respect to those sound recordings and the masters. There is, it's my understanding, that there is 7 million in an outstanding default judgment against the defendant, but the defendant stands to continue to receive royalties, both from the sound recordings, which flow through Sony by contract. They go initially to Sony, and then Sony will eventually provide it to the defendant once those default judgments are satisfied. But then, separate from that, there are those copyright or these performing art royalties that the defendant or his childhood friend Keith Calvert had been receiving through August of 2021, which were, several hundreds of thousands of dollars. That's completely separate from the money that was going to Sony and that Sony was retaining because it was subject to a default judgment. And so that the rights that he is entitled to receive 5 million. And so while it is true that there are 7 million in outstanding default judgments, most or a lot of that, I shouldn't say most of it, but a lot of that has already been retained by Sony and will be satisfied by that. And the defendant, the royalties will continue to accrue every single time that someone listens to the defendant's music. And so the objection is whether he has an ability in the future to pay a fine, and it's the government's position, given these substantial earnings, that the defendant will receive either from this $5 million judgment or from royalties coming through Sony. That's frankly, he does have the ability in the future. I would also note that defense counsel throughout this case has been retained. This is not an individual who has no money, and the question is not whether he has the money today. And finally, I think it's important to note that the defendant, frankly, was not candid with the court or with the probation department about his financial status. Nowhere in there does he mention that there was this contract for 5 million to sell these rights. It simply says that he understands that he's only getting a couple $1,000s per quarter. And that is now accurate with that the defendant continues to receive through, I think, Keith Calvert, but it completely neglected the fact that they had engaged in this contract right before this trial, before your honor. Hold on. Wait a minute. And so the government position is that we don't need to do further investigation. The question is whether he can pay, and the evidence is that he can in the future. Oh. The judge says, "What else do you have to say about this?" Jabo says, "Just, Your Honor, I don't think the U.S. attorney has this completely right, frankly. Again, and I'm not an entertainment lawyer, and I don't understand all of the inner workings of these types of negotiations. She's suggesting that there are two contracts that Sony is paying out on royalties, and that there's this separate source of money. That is not my understanding, and I don't know, again, where the U.S. attorney is getting this understanding that is separate sources of money. That is just not my understanding at all. I would say that the idea that he may in the future receive royalties as a result of use and of the music is probably true, but that is very speculative at this point because of, frankly, Sony, his music isn't being played. Isn't, it's not being played. There is not. It's not as, many sources will not play his music. So, and we see in his royalties that they went down dramatically at the time of his trial. So to suggest that he has some ability to pay future royalties, I think is very speculative. And I'm unaware of any information that he is entitled to 5 million. So I would, and obviously as an officer of the court, I would be obligated to tell you if I had a different understanding. I just don't. And I'm willing to look into it, but I do not think that the U.S. Attorney Office has it quite right. Judge says, I don't think it is your position that he is indigent, though, is it? Jabo says, I think he's pretty, well, I think he's pretty close to indigent. I mean, he doesn't have a source of money that's regular. The judge says, the only thing I will point out is, at least I don't recall the precise numbers, but the submission, and I also don't remember which addendum it was or which submission it was, but it did seem to me that they were, in the hundreds of thousands of dollars for periods in 2021. I don't know what the extent is, but like how likely that is to continue. You know, I think indigency is probably a stretch, but perhaps is there more either side wants to say about this? It does not sound like there is much that there is more that anybody that the government has its position, and your position is that there is no further investigation that is required, that there are sources of money. And I think counsel agrees, which makes some sense. There is a possibility of continued future income. You know, now is now. Who knows what is going to happen in the future? So I think I understand everybody's position. Is there anything else that you want to say on that topic? Jabo says, just Your Honor, that I would like the opportunity to explore. Unfortunately, Mr. Kelly, and this has been the historical thing for him, is that he doesn't fully understand all of his financial abilities to earn. That's, what's there. The nature of the contract. He relies on other people, and he's always relied on other people to advise him, often to his detriment. So I can't really turn to him and ask him to explain to me right this second because I don't think he knows. And so I think just because his name is on the contract does not necessarily mean he fully understands what the nature of that contract was, or even it may have been explained to him in a very basic terms. But so I would like the opportunity to look into it to make sure that we have reliable information that we're going on to depend on here. The judge says, well, I think that's a part of the sentence. The fine has to be determined today. So I will take into account what you said in considering the appropriateness of imposing a fine. I think that is all that needs to be said about that. I just want to conclude by saying that I do accept probation pre-sentence report, which is amended by the first and second addenda, and subject to those objections that I discussed and to the revisions of the guideline calculations that I discussed earlier. I think this is probably an appropriate time, unless I've forgotten something. This is an appropriate time to take a break. I do not know if you have a sense of how long each person will be. I am really mostly just thinking of time. My plan is at some point to break for lunch, and perhaps maybe we won't get through all of them for lunch, but my plan is then to break for lunch, and after that come back and finish the proceeding. So is 10 minutes enough time to get everybody together? All right. We will be in recess for 10 minutes. And then when we resume, we will hear from those victims. Excuse me.
Okay. Is
Yeah,
it
go
okay?
ahead.
Because we're taking a break right now.
Yeah. Come on.
Because I'm over here. I stay on top of it. I stay on top of this shit.
Yes, you do.
I've been on top of it. A lot of people were listening to me when I first came out and was talking about these certain situations and these different entities, but was something that you read that stuck out to me. And I'm gonna expand on it. And I wrote it down because I don't want to be just jabbering some shit out here. When she said in the future, for as earnings,
Uh,
let me ask you this, and I want to ask the listening audience: how would it be advantageous for him in the future when she's already in her mind, she's going to sentence him accordingly? For as making earnings, that means. Wait a minute, I'm getting ahead of myself because I already know this play. I know the play.
yeah.
She knows exactly how this works. But I asked this to the listening audience. Pay attention to wording. She already know this. She said, based upon maybe in the future, he will be able to make this. Now I'm finna take y'all somewhere. You are worth more dead than alive. So what this is just me in my mind, my wicked, crazy ass mind. She's already anticipating something. Not saying depth or nothing like that. So I don't want to alarm you people like that. But she's already anticipating for as his name being auctioned off, his catalog being auctioned off. And when it's auctioned off and it's under a different entity, money can generate based upon him because it's no way you could stop. See, when they got him on that, him saying, y'all should have stopped me 30 years ago. 30 years ago, that is not what he was saying. And it's so crazy how this 30 years is coming back into play based upon everything that we're seeing. I ask y'all people, I've been asking y'all people, pay attention to what is being said, not being wrote. Pay close attention. You got 30 rounds from over here on Debo. You got 30 rounds over here from Kales. I mean, y'all got to, hey, man, I could take you there, but I can't make you drink the water.
Do you know my daughter's number? Do you know my daughter's number was? From I don't know how long since she been playing basketball. She was 7 after Chris Webber, but guess what? Guess what she played under?
30.
30. Yeah, she wore 30.
That was Billy Owens
for so long.
I know you probably don't know Billy Owens, Syracuse, Billy Owens.
No, I don't know him.
But nevertheless, 30.
But I think she was kind of referring to his royalties, right? Don't you think she was adding his royalties in there too?
They do. Listen, I'll let y'all have that. If that's the way your mind operates and its functions on that level, you can have that. It's symbolicry. Pay attention, people.
Right.
Pay very close attention. I asked, and I typed this in the chat. I said, listen to the wording. How would you, being a federal judge, know what his potential earnings could be unless someone told you how this shit works?
Oh, yeah.
Come on.
Because remember, everybody's acting like they don't know if this the truth. They don't have the information.
I'd probably be murdered for the shit that I'm saying.
Oh, JoJo, don't say that.
Listen, I don't give a damn because I told these stupid motherfuckers before. What are you going to die for? What are you going to die for? You're going to die of something. But what are you going to die for? F-O-R. And you got all these fake ass supporters in here talking about, yeah, you down for the cop. I'm going to blow your asses out of the water. Just stay tuned. Stay
What
tuned.
you, what you talking about?
Yeah, you
What
know what
fake
I'm talking
supporters
about.
in him?
What's that?
Not in him.
No, ain't no fake
Oh,
supporters
okay.
in here. Ain't no fake supporters in here. And you know, I'm not knocking anyone out here. But let me stop getting sidetracked. I'm going back to what she said.
Yeah, we don't have no fakes on either side in him.
How would she know what his potential earnings could be unless someone told her? Pay attention. I jotted that and I wrote that down as it was said per
Right.
transcript. I wrote that down. And I was beginning to try to explain how she came in to be in the first place. She is part of the Me Too movement. She is part of the guys, the 6 guys that was locked up. Do y'all know that? Do any of y'all in this chat know that?
The 6 guys.
Yeah, I mean, come on, y'all. I'm speaking in codes.
What 6 guys?
Central Park said, "Come on now,
Oh, the Central Park.
come on now."
Oh no, tell me about that. She was the judge
Yeah,
on
she
that
was a
assignment?
goddamn judge.
No.
What?
Are you sure?
Go, look it up. Listen, by the sound of my voice, go look it up. I don't come on this mic speaking bullshit. I do my research. As y'all say, do your research. Man, I look it
Oh
up
wow.
by the sound of my voice right now. And it should be able, if you got Google search, to pull that up within 2 or 3 minutes as I'm speaking right now. Tell me her
But she was
involvement in it.
she was the lady.
Tell me her involvement with that. Anybody that's putting it up at the sound of my voice.
Let
You
me
gotta pay
see.
attention to
Let me go. I gotta
how
look
this shit
myself.
works. I told
Oh,
y'all when I
let me
first came
see.
out here, and many of y'all don't even know me from coming out here. I deal with things from a functional level. Now, there are some that was there with me when I came out. They're starting to see things differently too. Because I hear it. I hear it. Not based upon this situation, just based upon how things work.
Is she old enough to be?
Look at it, pull it up, and tell me, am
Wait a
I
minute.
lying?
No, wait a
Uh-oh.
minute.
Tell me, am I lying?
That ain't.
Huh? That ain't who? That ain't what? Or that ain't who?
That's Ann Donnelly.
What do you see? Because I know you got all them 100 devices in front of you.
Yeah, I don't see that. I see
Central Park 5. Put it up.
Central Park 5, right?
Exactly. Who appointed her? This is what I was trying to ask you that night.
I know Obama upon it. I know y'all said
Yeah,
that.
yeah, yeah,
I'm
yeah,
just.
yeah, yeah. Obama is part of an agenda, people. Sorry to tell y'all and bust y'all bubble.
I don't think it's Judge Don because I don't think she
Okay.
old Joe. Joe.
Look, this is what I'm asking you to do.
I'm looking.
Because see, when you're dealing with a situation like that, look all the way into it. Not
I hope
surface
it.
level shit.
Hold on. Wait a minute.
Surface level shit
I
is
think
just what
I
they
I
tell
think
you out
I
here.
heard
They
somebody
tell
say this
you a
before.
hamburger is, I mean, they put a picture of a hamburger out here that looks like something that is really not when you buy it. You know what I'm saying? You're like, this don't look like the hamburger I seen on TV. Of course not. But you bought into it. But I go back to this, what she just said, and I wrote it down. His future earnings. How would you know that? I'm asking that question. How in the hell would you know that? Man, it was once upon a time when this shit first started.
Mm.
I was listening to The Breakfast Club. The Breakfast Club with Charlamagne the God and DJ Envy. See, they are part of this establishment. They are part of the boule.
I
DJ
think I
Envy made
heard somebody say this before.
DJ Envy made the mistake of saying something on live. He said, "Is it time to start buying his stock up and buying his stock, meaning his intellectual property?" And that faggot ass motherfucker, Charlamagne the God, said, "Not yet." You know, they get on there, they be freelancing, and they don't even know what they be saying, and then they catch. They say that live is not even up no more because I went looking for it. That broadcast, rather, it's not even up anymore. So, in other words, they knew what was coming. He told him on live air, "Not yet." How in the fuck would you know that? Because you're a part of that boule. You know what these people finna do. You know exactly what they're getting ready
Okay, Joe, she's not. She went on the Central Pop. I think I know who's I ain't hollering at.
to do. Angie, I will
Yeah,
converse with you that on that situation later.
she
And
went
then
on
you
this.
will see what I mean by when I say she was part of that.
She was part of blocking Trump executive order from going into
I'm
effect.
not talking about nothing about no Trump. I don't even
I'm
want to
saying
go
what
there.
the case that she was on. And she
No,
ain't
no,
went
no,
on
no,
no
no, no,
Central
no.
Park 5.
Listen to what I'm saying. I will go into that in details later. And I'm going to show you where you're looking that you're not going to find it. Slow
Huh?
down. You're looking in the wrong places. Just let me ask you this. Let me ask you this
Mm-hmm.
since you went there. Is there ways of these people erasing their existence out here and their involvement?
Not no judge.
What, well, huh?
Not no judge.
Listen to what I'm saying and listen to what I'm asking you. Is there ways of these people? And I guess I need to reframe the question. Erasing their involvement. I guess that would be the best way to say it.
No, you said she was a judge over
Wait,
this,
wait,
so
wait, wait.
no.
That's not what I asked you. I know what I said. Excuse me for that.
No, no, Joe, no.
So there's no way that they can erase their involvement in a certain situation.
No, because it's
In
it has to be disclosed. That's part of the Constitution.
okay, all right. Who wrote the Constitution?
I don't know, but I gotta go back to reading. The white people.
It's not even so much to say white. See, that's not where I'm at. It's not so much of white people. It's
Okay, well,
people.
tell me the answer, Joe.
It's people that's in control. So I don't want people, no ethnicity, to think I am prejudiced in no shape, form, or fashion.
We know that.
No, but see, the way it's presented, it means like I'm against white people. No, I'm against establishment. Establishment meaning people that control, dictate, and tell you public policy and how it is put together, how it's worked, and how you're going to adhere to it. That's what I'm against. Based upon when it should be, as they say, democracy. When I said this before, when I really show you what democracy is, a lot of people will say, "Oh no, I ain't signed up for that." No, when you put your name on that voter registration and put it in popular, meaning your vote really don't mean nothing, but you put it in popular consignment, meaning the majority says this. Your elected fish officials are not elected, they are selected. See, when we're dealing with an industry, and I don't want to call it industry because that's a lack of better words, and I know better than. But we're dealing with an entity that's uncommon to the common folk. I know how they get down. Why? Because I studied this. I said this before. I've been on YouTube streets 15 years before y'all even thought about YouTube. Y'all probably just came on here 4 or 5 years ago. Some, not all. I understand this thing from a whole different aspect. And it's just not YouTube. I understand, and I studied politics. I understood public relations. I understand a whole lot of things. I just don't bring it out here. For what? It's like speaking a foreign language. A lot of people ain't gonna get it. They're not gonna understand it. And you know what? They have done an excellent job on it. The way I present it, they're gonna say JoJo is conspiratorial. It's a conspiracy. It's always a conspiracy. But I would ask each and every one of you guys, if conspiracy is such an anomaly, why does it even exist for me to even say that is such a thing? Nah, I don't want to deal with that. Because they have made conspiracy just that, a conspiracy. And they make you think conspiracy is a bad thing. But what that is, that's your lower chakras. And I say lower chakras telling you something. And then when it comes to the point of your higher chakras, see, that's a mind aspect of it. When you know it, when you could push the filter away and know what you know, you are amongst the ones that they are afraid of. Yes, indeed.
Right. Let me
Yes,
start
indeed.
back on this. You ready?
Yes, ma'am.
All right. I got a ways to go. All right. So they back in. Now the court clerk says, Jojo, say all rise. So give me a man's voice. Say all rise.
You know what? I'm going to say, oh, fuck y'all.
Jojo. Say
Yeah.
all
Go
rise.
ahead. And this is why I say that. Because I'm saying, go ahead and tell them your lies.
Huh?
Go ahead and speak your shit.
Tell them my lies.
No, when I say, come on now, you taking shit personal.
No.
Tell
I'm
them the
just saying.
lies that they taught you to tell them. That's it.
Huh? Me?
Oh my God. You finna speak it, right?
Yeah, but they ain't tell me.
So that will be
I'm just reading the
something that
transcript.
that is something that you are regurgitating, which I understand it to be a
I'm
lie.
not regurgitating. I'm reading it.
You're regurgitating it.
Okay.
Okay, so just go ahead and tell it. I'm not saying that is your viewpoint. You just speaking on what they saying.
I'm
Stop.
just reading. Right.
Stop.
Okay.
Stop looking for that.
Okay. The clerk, all rise. All right. The judge says, everybody can sit down. You know, I meant to say this at the beginning. I remove my mask when I'm speaking, and the parties are welcome to do that too. So just bear that in mind. All right. How would you like to proceed, Ms. Geddes? Um, Ms. Geddes says, Your Honor, we're just waiting for the victims to enter, and as soon as they do, we're prepared to. The judge says, okay. And Ms. Geddes says, I believe the first one will be Angela. The judge says, okay. And Ms. Geddes says, all right, Your Honor, I believe the first victim witness who is going to speak is Angela. Angela, could you speak? Please come up. Judge says, okay, I'm just going to ask you to take as much time as you need. Take as much time. This is a reminder to everybody who will be speaking. Our court reporter takes down everything that you say. I think those of you who testified at trial remember me telling you that. So do your best. Just keep your voice up and try to speak slowly. Go ahead. Prosecutor says, Your Honor, is it okay if Angela takes off her mask if she prefers while she's speaking? Judge says, yes, that is fine while you are speaking. Angela starts, says, the Pied Piper. You are both a magician and a technique and approach, carrying with you the promises of success, family, and love to entice those you thought nobody would miss. You presented these glittery gems as if they were gold as a means to rape, beat, mistreat, and continuously repeat your deplorable acts on both male and female children alike. With everyone addition of a new victim, you grew in wickedness, cockiness, diminished any form of empathy, sympathy, or self awareness, which soon became the breeding ground for your godlike complex. You use your fame and your power to groom and coach underage boys, girls from your own sexual gratification. You were doing, saying, and encouraging inexplicable things that no one should ever experience. Yet you not only did this to one person, but to many. You have created a a shared foundation of trauma that centers you as both the beginning and the end. You have manipulated millions into believing that perception of you, though, in your voice, yet behind closed doors, took ours, stripping at one thing that we were sure of right from beneath our feet. But today, I and so many of your victims take it back. We reclaim our names from beneath the shadows of your afflicted trauma. You brilliantly showcased it. You brilliantly showcased it down in life. Today, of all of days, leading to this very moment, we have sought to be heard, acknowledged, and cared for in a way that only we could do for ourselves. We are no longer preyed upon individuals, that we are no longer the preyed upon individuals that we once were. Today, we are individuals that have grown despite our afflicted trauma. We will never be able to live a life in complete unawareness or shock of danger or predatory people like yourself. But we will be able to live again because there is no way of falling back into your personal pit of trauma willingly. Today, I bring you to the awareness that your perceived ideation of being or only acting in this deplorable manner as your self-proclaimed alter ego, the Pied Piper of R&B, could not exist without the living and deliberate breath of Robert Sylvester Kelly. I am Javante. I am Tiffany. I am Aaliyah Dana Houghton. I'm a complete representation of the group second chapter. I am a representation of every woman, boy, child, man that you've ever afflicted with your deplorable, inexplicable act. I pray that God reaches your soul and touches your heart, and that you will find awareness of your own deplorable behavior. And with that, I leave you with yourself, Robert Sylvester Kelly.
Okay, let me say
Uh,
something.
Oh,
Let
Joe,
me
it's
say
a
something.
lot. I gotta read. Go ahead though.
Oh, let me say something. Because see, right here, that is who's
That's
testifying.
Javante.
Javante.
Uh-huh.
Javante, you work at Holland. You don't have the word inexplicable in your lexicon. No pun intended. So I'm trying to tell y'all how this shit works and show y'all. That woman, inexplicable with your fucked up ass.
Yeah.
Someone wrote that for her. And it wasn't her. Those are not her words. Inexplicable is the equivalent, and this is no knock on somebody in that magnitude, is fucked up ass. Straight up. Let's keep this shit real. Because if we're going to keep it real, we're going to keep it $1.20. She don't know the word inexplicable. Let's keep this shit real. Think about this. Inexplicable in her mindset is fucked up ass. With your fucked up ass, it's not going to be inexplicable. Stop. Think how it's put together. That woman don't know the word inexplicable because last time I heard she was working at O'Reilly's. Go on section A, go on section B in this store and find 37A. It's a carburetor.
But Joe, that don't mean that she doesn't know.
No. Listen to the wording of that carefully crafted ass statement she gave. See, listen, stop fucking playing with me. That's just why I'm too raw for you people, man. I am too fucking raw. And I know what it is. She don't know inexplicable. See, I listened to everything you said, and that key word caught me. It's like, bam, there you go. This is what you are.
But it's not like it's a big word.
So it's not. It's not. But this is what I'm trying to tell you. It's not a big word.
Okay.
It's not a big word, but give it. See, this is why people fuck up at. See, because I'm glad you said that. Now I can attack it on another base.
Well, hold on. Let me finish reading the rest of these.
Given what I heard her on other platforms, inexplicable is something she couldn't even fathom. But continue on.
All right. Prosecutor Ms. Geddes says, Your Honor, the next witness is adding. The judge says, and I'm just going to tell you to take your time. Addie, I am Jane Doe Addie. Freedom is not free. We have to constantly be fighting for our basic human rights. Writing this impact statement was hard. I've written several drafts and revealed emotional triggers. This was extremely hard to do so because of such a sensitive topic. I know there are fans of R. Kelly, Robert Kelly, that don't believe us, and there are supporters of the victims as well. I want to make my statement clear to the masses, our society, and the world. After experiencing and revealing my childhood trauma, I am finally at a place of gratitude. I am grateful to the jury, the judge, and all the ladies and gentlemen of the Justice Department. You are my guardian angels. I once lost hope in our justice system, but you restored my faith. I also want to give thanks and express my gratitude to my attorney, Leon M. Walsh, and I also want to give thanks and gratitude to my attorney, Leon M. Walsh and Grinnell Law. Without their guidance, I would be totally lost. I especially want to say thank you to the other victims and witnesses for speaking out. I feel your pain with this collective of the people. Justice was served, and I hope that the world can make a stand together against violent crimes against sexual abuse and continue to doing so. It's a constant battle. I never thought I would experience individuals that actually care about fighting to preserve and protect our rights. In 1994, it was a different time. There was no real awareness, no real internet access, and definitely no social media.
Listen how this tramp is chronologically ordering a timeline. But go ahead.
JoJo, I got 100 pages.
I'm gonna say this and I'm gonna end mine, I promise you. And I'm sorry for interrupting you. There's no way I went to college. I had theses and all of that kind of thing. There's no way a Trump like that is going to put a timeline together and make it sound so cohesive that it fits what she just priorly said. I'm not finna sit up here and go through that. I'm finna get up off this panel because that shit there is irritating to listen to. and to be persuaded as a group of people thinking this individual is actually saying that. And I'm sorry, Angie, by all due respect, but if y'all think this individual is actually composing what she is saying, you are fooled in a way that I cannot even begin to put in words how you are fooled. Because me, in all of my studies, couldn't even compose something carefully structured the way she's saying. Because everything after a period comes along something supporting. It's no way that Tramp can do that. That's no
Jojo, how
way.
you know this woman's a
You know
tramp?
why I can
Oh my
say it?
God.
You know why I can say it? Because it is what it is. I study people like they study us. Stop playing with me. And listen, I'm going to give it to her because they bought it. But I will put the Holy Ghost and 50 more of them on it that she has nothing and had nothing to do with that writing. Nothing. Because
They
I
probably
already
had. I mean,
disappointed.
someone
Wait
probably
a
had
minute,
some
Nancy.
help.
Let me say this because I'm finna get up out of here. She has nothing to do with that writing or the manuscript and the structure of it alone. I just told you what a trifling ass person like that would do. She would say, "You fucked over me. You said you were gonna do this for me. How in the fuck you come along and put a well composed letter together? You are from the hood, from Chicago. When they found you, you was working at O'Reilly. Stop
No, this a
playing
different
around here.
person.
Slow down,
This a
slow
different
down.
person. This a
Listen,
different person.
who was you reading? Who was you
This is
reading?
Addie. I went to. This is a different person.
Okay, Annie. Annie sounds like she got some kind of descent in her that would help her. See, these people are very functionally smart on how they compose it because they don't want to go so far to the point that it don't sound believable. But you're dealing with ethnicities and you're dealing with what's believable and what's not. When I point at that word out that I know that person prior to you reading who you just said you're reading, it's not in a lexicon. I know it's not. I know it's not because I've heard her on platforms and all she say, nigga this, nigga that, that nigga did that. Now all of a sudden she sat down and put her words together and formulated 4-syllable words that she don't even know the meaning of? No, that's script. That's script. And I'm finna get up out of here, man. Love y'all to life, man. I'm not fucking around listening to this shit because it's frustrating on my
Okay.
behalf. And y'all give Angie a shout out because she's doing just what she do. She reads the shit as it comes in. It's not her. This is what is presented. But when I hear bullshit, I don't need to hear. I tell y'all as I'm leaving and leaving this podium, because I'm on a podium right now. Bullshit runs a mile. Shit. Go ahead, Andy. I'm sorry. Go ahead.
Okay. All right. Okay. It was a time when my generation was not expected to speak out, just like my mom's generation. Everything was about silence, regardless of how traumatic the experience. It was generally brushed under the rug. I am not my mom's generation. I am no longer living in that mindset. My mom supports me, speaking out about my sexual assault. It's unacceptable to live in silence, and it is not what we should consider a social norm. It is inhumane to endure any form of domestic violence, sexual assault, sex trafficking, any form of human trafficking. It's really modern day slavery right in plain sight. During my testimony, my mom was afraid that we would experience retaliation. It's the main reason I chose to stay anonymous, to protect my family. I can only imagine the pain and suffering the other moms, victims have gone through, the shaming and the blaming. I want all of the moms to know I understand, and you are not to blame. The impact that social media bullying has on victims and their families. I ask for people to please stop. Imagine if it was your daughter or son. Imagine going through your life feeling guilt, despair, fear, having thoughts of suicide, feeling worthless and misunderstood. Now imagine your young daughter or son experiencing this trauma. How will you handle this? I did not know that going to that concert on September 1994 was going to change my life forever. I was just a young teenage girl, a huge fan of Aaliyah, and I wanted to see her perform. That day, she did not perform. I never knew why she didn't perform that day until the day of my testimony. My sexual assault happened nearly 28 years ago. I was a minor, 17 years old. I was afraid, naive, and I didn't know how to handle the situation. I stepped forward, and as an adult, because I wanted to stop the vicious cycle, I felt so many different emotions and the guilt of not speaking out sooner. Being silent is just not right. Being silent is allowing sexual abuse to continue, and being silent changes nothing. Because being silent leaves you empty, like silence. It's a very lonely place where depression and thoughts of suicide consumes you. In order to set yourself free, you have to set your mind free. In a world where people get victimized every day, it only takes one voice to start the conversation. Like everyday people, I suffer just like most of us do in our society. I suffer mostly from low self esteem, nightmares, remorse, and shame. I suffer from within my heart with emotional breakdowns, thoughts of suicide, and self sabotaging. I didn't have the confidence to speak out sooner. I was seriously suffering in silence and loss. I realized that it was important to impact the lives of other victims that would not get justice every day. There are countless victims that never experience or receive justice. I'm here not to judge. I am not here for any money, and I am definitely not here for Hollywood. I am here for you. I am here to represent your story. I am not here to represent your story that belongs to you. I am here to tell you the truth. You do not need to be afraid. I was never in a relationship with Robert Kelly. In fact, during my testimony, it was my first time seeing Robert Kelly since my sexual assault many, many years ago. I am only seeking justice and want the world to know that every person matters. I get no restitution. I have no rights due to Florida law. One day these laws will be reformed. I only have my concert program and my trauma from that event. With that, I can finally have closure as I stand here today speaking out and never feeling ashamed again. Due to the trauma of my sexual assault, I was too fearful to pursue my entertainment career after countless years of hard work. Every time there was an opportunity to move forward, my trauma held me back. I lived this way for many years. Although there was times I had good days, my fear stopped me from pursuing my dreams, ultimately not just affecting my life, but countless victims after me. I feel if I did not let fear consume me, other victims would not have suffered. This is what I have to endure. I only want Robert Kelly put in prison so he cannot cause any more pain and suffering to others. In 19 in 2019, after I thought I was healed and could move on, God made a statement. I can no longer live in fear. I had to make a stand. The last 4 years was a rude awakening of how my silence hurt others. I could not sleep at night knowing this. I hope that Robert Kelly cannot sleep at night knowing this is what he has done. Now it's time to focus on my determination, my ambition and dreams. It is time to heal again. I believe that we, as human beings overall, stand for good. I still believe in unconditional love. I am no longer a minor. I'm a grown woman, stronger and ready to move forward. And all in all, it's a shame that our world is not a perfect place, but it's good to know that out of darkness comes light. I don't have to live in fear anymore. I don't have to be silent. If it wasn't for the jury hearing out stories, facts, and evidence, Robert Kelly would continue this horrific abuse. Thank you for listening. Thank you for understanding. After decades, I never thought this day would come that victims of Robert Kelly will get closure. God bless you all. The judge says, Thank you very much. Prosecutor says, Your Honor. We'll next hear from Jane Doe number 9, who has requested that her attorney, Gloria Allred, join her. The judge says, Okay. Jane Doe number 9 says, My name is Lizette Martinez, and at the age of 17, while walking in the Aventura Mall in Miami, Florida, with other high school girlfriends, I was approached by Robert Sylvester Kelly. During this time, all I dreamed of was becoming a singer. Singing was my life, and it's all I ever wanted to do. I was a happy 17-year-old with big dreams and an optimistic view of who I was and who I would become. At the age of 6, I was sexually abused by a family member. And by the age of 12, while babysitting, I was sexually abused by the parent of the child I was watching. By the time I was approached by Robert, I believed sexual abuse was a part of my life. I didn't understand the trauma I had been exposed to. My home life was tough. We moved around a lot, and by the time I was a senior in North Miami Beach High School senior, I had already attended 4 different high schools. Despite the chaotic life my parents exposed me to, I managed to get decent grades. I was a cheerleader, on the debate team, part of the school chorus, drama club, and in an RB group. I won a singing competition at a Florida radio station, which really gave me the feeling and drive to want to sing professionally. January 1995, everything changed forever. I never imagined my life would turn into what it did at the hands of a predator and his enablers. At first, Robert offered to mentor me and said he would help me. I believed him. I really wanted to make it, not only to live out my dreams, but also help my struggling family. First, the abuse started with grooming me to believe that he was the only person that could really help me and the only person that cared about my well being. I had to listen to him, and he knew what was best. My family and my friends are jealous of me. I had to do what he said or else. At the age of 17, 2 months after meeting Rob at the mall, I was taken to the studio, the Hit Factory in North Miami, to listen to a record, You Remind Me of Something, a song he had just finished recording. I was taken by his bodyguard, Big John. We then went to a house on Chase Avenue in Miami Beach, and there was a party going on. I remember there were many young girls like myself at the party. I felt uncomfortable and extremely out of place. I was handed an alcohol drink and was told to drink it. It was the first time I ever tasted alcohol. I was then taken to the room by Robert and a few minutes later sexually assaulted. After he was done, he got off me and left me there in shock, confused, and in tears. I didn't know what to do. I didn't know what my life had just become. Life after that night quickly changed from being this bubbly teenager into a really depressed young girl who was being alienated from everyone and everything I loved, including friends and family. This is when a lifetime of depression and PTSD started for me. I stopped going to school. It, as he put it, if you want to make it, you got to listen to me. The next months were much of the same. No music, mentoring, just forced sex upon me in front of people at music studios, hotels, cars while friends or his entourage sat around in the back seat. Turning 18 now gave him the opportunity to have me travel to Chicago to be his sex slave, which lasted a few years. Not only was I sexually and physically and mentally abused, I was infected with an incurable disease. I lived with it for over 20 years. I do not know how to put a price on all I've gone through. If I could go back in time and never step into that mall, I would. Not a day goes by that I don't think about what happened to me. It doesn't seem to go away. I just live with the trauma. In 2018, I decided to speak out about my experience because I was a mother by then. And hearing about other victims and their experiences, I no longer felt guilt and shame. I stopped blaming myself and started to understand that none of it was my fault. Robert destroyed my young adult life. He took away my innocence and set the tone for what would happen to me as an adult and the patterns that followed with being abused over and over by men. Today, I'm 45 and a mother, and I struggle with my health, mental health, and just trying to move forward from all of this. Diagnosed with PTSD, depression, and anxiety, and what I live with and have lived with. Robert, you destroyed so many people's lives, and being abused doesn't give you the right. It's not an excuse. I just want you to sit with yourself, get help, and realize what you did. Thank you. All right, let me come right here and check on y'all real quick. What's good? What's good? What's good? All right, give me a minute, y'all. Give me a minute. All right, eyes back, y'all. And where am I? Okay. Okay, it says, the judge says, thank you very much. And the prosecutor said, we'll next hear from Jane Doe number two. Jane Doe number two starts. It's been 23 years since we knew each other, and you have victimized a lot of girls since then. I feel like I should refresh your memory. It was 1999. I was a teenager, and you were a 31-year-old pedophile ready to ruin another young lady's life. During our time together, you degraded me, you humiliated me, you made me do things that broke my spirit. You were manipulative, abusive, and controlling. I literally wished that I would die because of how low you made me feel. As a teenager, I didn't know how to say no to R. Kelly when he told me to perform oral sex on him after he had just played an hour of basketball and we were in a car full of his male 30 something year old friends. I did as I was told when you told me to moan and do it louder while you forced your penis in and out of my mouth. Do you remember that? Before I met you, my self-esteem was already delicate, but after you, my self-esteem became was completely decimated. I was just a teenager who felt special because someone who was special to the world was interested in me. At my age, now I look back and I know that I was just a child. I was somebody's child, and you couldn't have cared less about destroying me and my future. You couldn't have cared less about paralyzing me with fear that one day a video of me having sex with you would see the light of day. Hmm? Who was this? I spent my entire 20s and 30s avoiding any mention of your name or any songs of yours. I always wondered why no one was doing anything to stop you and why I was having to hear your voice over the radio. Millions of people saw you on a video basically raping a 14-year-old girl. My heart breaks for that girl and her family. Anytime your name came up in the news, I would feel suffocated with fear that one day my family might see me at an absolute lowest point of my life, a time when I wanted to die because I was filled with so much shame and felt completely worthless. You stripped me of my dignity and self respect. I'm sorry. I do not want to interrupt his conversation. At any time your name came up in the news, I would feel suffocated with fear that one day my family might see me at my absolute lowest point of my life. A time I wanted to die because I was filled with so much shame and felt completely worthless. You stripped me of my dignity, of my self respect, and because of you, I have a sexually transmitted disease that I will carry with me forever. Because of you, I had to wait in line at free clinics trying to get medical attention for this disease because I had no money and I had no insurance or health care. And while I was in line trying to get medicine to rid my body of your disease, you were out there destroying other girls with no remorse. No price is too high for someone else to pay for your happiness. When I decided to testify against you, the same suffocating fear I knew as a 17-year-old in your presence came rushing back to me. I knew testifying was something that I had to do, but I really didn't want to. I really didn't want to discuss and relive the trauma again. So I blocked it, and I didn't think about it until I was on the stand. Somehow, finally, when I testified against you, I wasn't afraid anymore. I no longer saw you as a special person with special talents. I saw you for the criminal you are. But after I left New York and went on with my life, I felt victimized all over again. All those memories came rushing back to me, and I find myself sobbing uncontrollably at random times in the day, having to be consoled by my husband and hide my tears from my kids. I felt victimized by you all over again. And I don't know if I'll ever be whole and healed after what you put me through. What you did have left me permanent, have left a permanent stain on my life that I'll never be able to wash away. I'm sure you never think of that. You took pleasure in humiliating me. You enjoyed seeing me reach new lows at your command. You knew you were infecting me with a lifelong STD. You are an abuser. You are shameless. You are disgusting. And you are self serving. You only had 8 months with me and you completely broke me. I can't imagine how this was for girls who were with you for years. I feel sorry for you. Some horrible things must have happened to you to make you have such a sick and twisted mind. I hope you go to jail for the rest of your life because I believe that if you were ever to be released, you will only continue your atrocious behavior. You've had decades of remorseless freedom in which you made the deliberate choice to continue sexually abusing hundreds of women, taking away their freedom and their ability to move through this world as strong, empowered, and unburdened humans. Now, it's your turn to have your freedom taken from you. You experience what it feels like to be robbed of your freedom, and it still won't even be an ounce of the pain and suffering you brought upon all of the victims who have suffered at your hands. But this is the best that any of us can hope for. I'd like to thank the court and Judge Donnelly for this opportunity to share my story and to give my statement. Please let's see and finally feel some justice. The Judge Donnelly said, "Thank you very much." The prosecutor says, "The next individual to speak will be Sonia. Actually, we're going to move to Kitty Jones." Judge says, "If you would like, you can remove your mask." Kitty Jones starts. In 2017, rumors had been circulating on blogs about my time with Robert Kelly, and I was then approached by Rolling Stone to share my story from 2011, from 2011 to 2013. It was a dark story of abuse and sexual coercion. I no longer wanted to give Robert Kelly the luxury of my silence, so I decided to not to be anonymous. I didn't know the impact of my story would have at this time, but it opened the floodgates and empowered many others between 2018 and 2020 to start contacting authorities and media to finally tell their stories publicly. In that article, I shared with the world that I encountered over a 2 year period living with Robert Kelly, which included humiliating sexual abuse, physical abuse, severe weight loss due to punishments of days going without food. Be- Before I met Robert Kelly, I was a vibrant, happy, successful radio personality, a well known socialite. I was living the life of my dreams. And then I met him. And like many others, I fell for the person who shared his hurts and betrayals of his past. Upon hearing those things, I wanted to protect him and earn his trust. And I vowed to never speak of my time with him or tell his darkest secrets, even the things he had done to me. I planned to take it to my grave. After I left his home at the end of 2013, I still had the mindset to never tell until one day, 3 years later, my worst fears came true. I got wind that he was doing to others what he had done to me, and I panicked at the thought of someone much younger than me having to experience those things and the emotional and mental impact it would have on them years later. So I had to speak up because my silence up until then and others who never publicly came forward, allowed this man to feel invincible. He had a reason to feel invincible. He was still performing at his sold out concerts and Grammy parties, writing songs for the biggest names in music, being praised by his peers, performing on award shows, and standing ovations. And radio stations, including the one that I used to work at, supported his music. The black community would crown him the king of R&B music at any time during the topic came up, and they still do. Knowing his fan base were women who looked like many of his victims, he knew the public would never believe myself or others if we came forward. While this about Robert Kelly, it made me feel powerless and silent. It became really dark, frightening, and lonely living with those memories, secrets left with wondering why me. It's been difficult to be in other relationships, and I've never gone back to being the social butterfly I once was. I've had therapy and counseling to cope with my time living with him and learned how not to blame myself. But today, it doesn't feel dark. The secrets are out, and the pain of my past with Robert Kelly has become my power, and I feel heard and believed. Today, my hope is that the amount of time being asked by the prosecutors is given, considering the long list of survivors and families that have been affected and lives that have been forever changed. Many of us have been waiting for this day to come. Thank you. The judge says, thank you very much. And the prosecutor says, Your Honor, could I have a moment? The judge says, sure. Prosecutor says the next individual to speak will be Charles on behalf of Faith and Kelly. Okay. Faith. This is Faith. Good morning, everybody. I didn't really plan on saying anything today. I was going to let my dad speak, but just sitting down, I was overtaken with a lot of emotion, and I just want to get a few things out of off my chest as we close this. I'm closing this chapter in my life as well. I started at 19 telling my story, and it's been a long journey. My concern is not if you're sorry. I can see that you're not. I can see your enablers around. I can see their face as well as your attorney's faces as the woman, the victims are speaking. I hope that you get some help as well as ask God for forgiveness, as well as I've taken accountability for my mistakes and the times I should have said no, but I said yes. I have forgiven myself. I hope you forgive yourself. But with forgiving yourself, you have to take accountability. So I really hope that you've done that. And the people next to you, it isn't just about me. It's about the generations to come. I'm standing next to a man that I didn't know till after I started speaking out about my story. But my dad was molested as a child from the age of 5, and he never molested me, molested anyone else, caused harm to somebody. And I look back and I was at that age, I was seeking love from a man 3 times my age when there was a man that literally has given me life that has gone through similar situations that I should have never been seeking love from. So so to my parents, I want to apologize to you guys for allowing myself to forget about the way you all raised me. I'm not going to sit here and fold. I didn't want to cry, but I'm doing it. I forgive myself. It's easy to point the blame on parents, but I was one of those that my parents that they didn't have to give me away. I lied to them. I was chasing something deeper than myself that I wasn't ready for, and I ended up being abused, humiliated. And I want to say thank you, Mom. Thank you, Dad, for sticking by my side. It's just so crazy to me. Like I said, I'm looking at somebody who has been molested, abused, gone through trauma, similar trauma that Robert has. And my dad is an outstanding man who, through this time, has shown me nothing but compassion and forgiveness that I didn't even want to show myself. And to those who judge, who make faces, who keep looking back, I hope that you never have daughters, cousins, grandchildren that have to look at their abusers in the face and be chastised by people. It has been a brutally long process, and there are times where I didn't know how I was going to make it or how I could even face another day. But thankful to Gloria Lee Merrick, my parents, and the ladies who have been on this journey as well. I thank you guys, and I'm so proud of y'all. And everybody has their day as well as he is. He has this day, and he has to face what we had to say. Every day since this has started, we have heard from your supporters, from the people who harass us, harass our family. So I hope that this very short day of hearing what we have to say sticks with you. Thank you to the attorneys, to the prosecutors who have worked with us, even when we wanted to give up. Days I didn't even want to talk about it. You guys, y'all kept us going a lot. And I don't think you guys realize how important it is that we made it here because we felt like nobody cared. It's been a long, long, long journey. So I just want to wish everybody healing from the situation on both parties. I hope, yes, I hope if you have daughters, daughters, to his lawyers, that you all can explain how could you represent and be on somebody's side that abused so many women? And I'll leave that to you guys. The judge says thank you. And the next up to speak, I guess, is Faith Father Charles. Good morning to everybody. I think Faith said she wasn't going to say anything, and I was just going to talk. I like to really. I didn't come to bash Mr. Kelly. I think he's in a very serious situation. But I do want to ask you, Mr. Kelly, to look at me and from man to man, father to father, you have daughters, and just think what I might be feeling. Put yourself in my shoes. I've certainly put myself in your shoes. And I mentioned that that in a minute. Hold on, let me see. I'll certainly put myself in your shoes, and I'll mention that in a minute. However, I remember watching you so many times in different videos while all of this was going on, and you didn't seem to be remorseful. You didn't seem to admit to anything, and that made me feel some kind of way as a man and as a father whose daughter had been victimized. And I'm sure you know about that because in the Gail King interview, you mentioned when she asked you, what would you do and how would you feel if someone did it to your daughter? And your response was, I would, you know what? I felt all of that at times as a man and as a father. However, I put myself in your shoes too. And it's so easy to hate. It's so easy to hate, but I refuse to hate. I don't wish bad on any person. We've failed ourselves. We failed God at times. Certainly I have. And what keeps me grounded is the fact that I've messed up so many times and God was there for me. So I want to offer you some hope today. And I want to let you know that this family, we're not choosing to hate you. Yeah, we're suffering. We're suffering because so many people love you. They hate us. They love your music. They hate us. They talk about my daughter. They threaten us. They say all things about us because they love you and your music. But yet, I put myself in your shoes because I realize there are people that love you. I know that you have family, you have brothers, you have uncles, you have friends, you have cousins. They don't just love you for your music. I'm sure they love you for who you are. And for their sake, I I hope things work out for you. It's not for me to determine it, but if I was you, what I would want, and I said this before, I would want forgiveness. I would want mercy. I would want compassion. And in reality, that is what I wish for you. I wish the court could have mercy upon you and compassion. I don't wish bad upon any man. I don't wish a life sentence on you because life is short as it is. And I believe that everybody deserves another chance. And everybody can fix their wrongs. And they can work together for their good if they learn from it. But before you can learn from something, you have to admit that you've done something wrong. As I get ready to to sit down, I was thinking about this wonderful God that we serve, that loves you, that loves everybody in this room, and I have no doubt that He will forgive you. But the only way He can forgive you, you have to confess that you did something. You have to confess and admit that you did something, and so it's left up to you. There was a thief on the cross that condemned to die, and he had been a thief all his life, and he was losing his life. But at the death, he gained eternal life. He gained eternal life because he admitted that he was a thief. He admitted that he had done wrong. He had never served God, but God forgave him because he admitted it. I'm offering you that hope today, that you would come to the reality that you've done something wrong to all of these victims. Certainly, these multitude of women are not all lying. And so, I wish you well. I don't wish any bad upon you. I know there's people who love you and care about you, and you can learn from this and you can recover from this because there's a God that loves and there's a God that forgives. And my family and I, we choose to walk in love and walk in forgiveness, even though my daughter's been victimized. God bless you. And Judge says, thank you so much. And prosecutor said the next one, and I believe final individual to speak is Sonia. Sonia says, good morning, Judge. I actually wasn't going to speak today because I emailed my statement. However, I just want to make sure that it's part of the record that, for most almost 2 decades, I have lived in fear. I have tried to raise a young girl the right way, but at the same time, I have that happened to me, almost 20 years ago that I am living with. And to know that I was dealing with that and trying to raise her and trying to raise her in a good home to where she wouldn't go out and trust somebody and be so naive. It was really hard. It was it was extremely hard. There was times we had our own place, but I would pick up and leave, pack a bag and go into my grandma's. And I did that because I was threatened. I was threatened. I was watched by his entourage. I was followed. There were numerous times that, I was scared for my life. I was scared for my daughter's life. I wouldn't let her come home for, a certain amount of time because I was scared that, he was going to have someone that, was going to come and do something to me because of my platform that I had. And I was afraid that he thought that I was going to use it. So I just want to say one thing, that I hope and I pray to God that we can all heal. And I have almost 20 years of I haven't been able to speak to anyone about it. And it has been extremely hard. But I hope and pray to God that we all heal, including Mr. Kelly. And that's really all I want to say. I emailed my statement. I don't want to read it from it today, but I thank you. And the judge says, thank you very much. And the prosecutor says, is there anybody else? And the prosecutor says, no, no, Your Honor. I don't believe there's anyone else who wished to speak. All right. Just got a few more pages to go, y'all. Let me check on y'all. Let me run to the kitchen real quick. Give me 1 minute, 1 minute. Thank you, y'all. All right, back. Okay. Judge says, all right. Well, first of all, let me thank each witness who made a statement here today. I think, given the time, that this is a good time to take a break for lunch. So we'll resume. Just hold on a second. All right, we'll resume at 2:15. Okay, so they're back in. All right. Just says good afternoon, everyone. You can all have a seat. All right. As I said before, it's fine to remove your mask when you're speaking. At this point, I have reviewed the sentencing submissions from both sides, but I'm prepared to hear from you in the following order. First, from Ms. Bojing, from the government, and then if Mr. Kelly has anything to say, I'll hear from him as well, Ms. Bojing. I'll also tell you that if you rather sit, I think sometimes it's easier to use the microphone. So that's perfectly fine. Ms. Bojing says, thank you, Your Honor. She starts. Mr. Kelly stands before this court convicted of numerous serious offenses and a guideline range of life of imprisonment. And while today is a day for his accusers to share their stories, it's also a day about Mr. Kelly, who he is, in fact, a human being, and a day where this court must consider all the 3553A factors in fashioning an appropriate sentence for him, not based on inflamed emotions or impassioned feelings or vengeance, but to impose a sentence that is not greater than necessary to comply with the purposes of sentencing. Defendant has had a horrific label slapped on him, and we understand that some people believe that those labels are well deserved, but he is not obligated to own those labels or to confess, which is not to say that Mr. Kelly does not have regret or that he does not feel anything or refuses to take responsibility for conduct. I would remind the court that Mr. Kelly does have pending charges in at least two different jurisdictions as we sit here today. But to be clear, Mr. Kelly and his defense team respect this process and understand the process. But there seems to be a sentiment that Mr. Kelly should not be even afforded the basic safeguards our Constitution provides to him. His lawyers are not his enablers. They are his lawyers and have a duty and an obligation to represent him. As a matter of both ethics and constitution, our duties lie with our clients. And if it makes any of the speakers feel any better today, my staff, my family, and my children are threatened fairly regularly and harassed. There are strong emotions on both sides. This is not a one sided affair. But Mr. Kelly is entitled to a devoted defense team, which we work unapologetically. He is also permitted to maintain his innocence and disagree with some of the characterizations that have been made of him. Mob justice is very in vogue today, popular on social media, even mainstream media. Um, the judge says, Miss Von Jean, I'm going to ask that you address me and not the audience, if you could. Thank you so much. Miss Von Jean continues. There is sentiment that there are only good people and bad people, black and white, winners and losers. But Your Honor knows that the attitude is not for the courtroom. The court is tasked with something far more complicated. The statute directs this court to impose a sentence sufficient, but not greater than necessary, to comply with the purpose of sentencing. The government seeks a sentence greater than 25 years in prison. This is a tantamount to life sentence. The government seeks a sentence based on what it considers to be a lifetime of bad behavior toward women, but this court must distinguish between what is boorish and bad behavior and what is criminal conduct. The lines have been terribly blurred at times. There may be conduct that this court and individuals on both sides of the aisle or in the public feel is contemptible, but it doesn't necessarily make it criminal. We have heard testimony or statements from some women today who did not testify at trial. Their their statements have not been tested by adversarial process. And we have heard many stories of what individuals that have testified here today deemed to be the defendant is a bad person. But courts do not try people's character, nor do they sentence people for bad character. Now, contrary to the government's argument, the defendant does appreciate that he is convicted. Wait a minute. Now, contrary to the government's argument, the defendant does appreciate that he is convicted of serious offenses. He is facing those consequences. But again, he is not obligated to accept the government's narrative hook, line and sinker, and he does not. Now, one of the factors that this court must look at is the nature of the circumstances of the offenses of which Mr. Kelly has been convicted. It is true that the court denied Mr. Kelly's post trial motions, and we will have our day to argue the sufficiency of the evidence before the Court of Appeals. Today is not that day, but even taking the government's evidence in that best light with all reasonable inferences resolved in the government's favor, the offenses for which the defendant has been convicted do not rise to the level of seriousness that justify essentially a life sentence for him. There are mitigating aspects to these offenses that the court should consider. The defendant has laid them out in her sentencing memorandum, and I would like to point out a few mitigating circumstances of these offenses, which is not to say that we don't recognize that they are serious. Defendant was convicted of a racketeering act related to four separate women. Stephanie, who we heard from here today, 17-year-old Geronda, 16-year-old Jane, who was 17, and 18-year-old and older, and then Faith, who was 19 years old. The sexual exploitation offense for which Mr. Kelly was convicted as it relates to Stephanie stemmed from an occurrence in 1999. It's her claim that when she was 17 years old, he recorded a consensual sexual encounter with her. Stephanie was consenting legal age in the state of Illinois, and that crime for which he has been convicted was fact that it was videotaped. Again, not to suggest that it is not an offense for that carries significant punishments, but this is not a crime that involved an act of child sexual abuse or an act of coercion or an act of violence or a particularly young child. On the continuum of child pornography offenses, these have mitigating factors. Again, he stands convicted of a very serious offense, and the guideline range reflect that, but I think there needs to be perspective and reasonableness when considering each of these offenses separately. In connection with Geronda, I will point out that, as the court is well aware, that we do take issue with the forced labor conviction. Although there was testimony from Geronda about a physical assault and then followed by an act of a sexual act, it is our position that even in the context of forced labor, this simply doesn't rise to a particularly aggravating event of forced labor. Again, it's a serious offense. He faces the consequences for it, but the conduct itself cannot be squared with the pragmatic forced labor cases that we typically see. We obviously disagree about whether the evidence was sufficient to establish that offense, but even assuming it was, our position is that the offense itself cannot be deemed particularly aggravating in the context of the facts. Looking at the offenses, the Mann Act violation, offenses in connection with Jane. First, there is the early 2015 event where Jane readily admits that she lied to Mr. Kelly about her age. Our position, of course, is that he did not induce her to travel with him to California. In fact, quite the opposite. She was with with the assistance of her parents, was very eager to travel with him, and he did not know that she was underage. Again, this is a specific Mann Act violation. Again, I would remind the court that even by Jane's own testimony, the police arrived at that hotel room. They carded her. Mr. Kelly was none the wiser. So when the defendant or when the government argues that the defendant was on notice of her age, it is simply not the case that he was on notice of her age. We can take issue with the fact that she was younger than him, but at the end of the day, he believed, and the government concedes, that he did not know and was not apprised of the fact that she was younger, was under the age of 18 when she traveled to Florida with him, or from Florida to California with him. She did so not by any inducements or any coercion or any type of manipulation, frankly. We have the real time text messages with her mother, in which she is there willingly and encouraged. Again, he's been convicted of this offenses, and we will argue our sufficiency of the evidence claims at a later point. But in the context of this offense, this is not an egregious Mann Act violation. This is not forced prostitution of Jane. This is a unique set of circumstances, and this court should take into account the nature and circumstances of this particular offense when considering all of the conduct for which Mr. Kelly faces sentencing today. The same can be said of the Mann Act violation that relates to the trip to California in 2015, later in 2015. Jane was at that point a month or two shy of her 18th birthday. By her own testimony, she was living with the defendant in what was a consensual relationship in the state of Illinois. Again, we can all take issue with the age difference, but at the end of the day, this was not an illegal relationship in the state of Illinois. But for traveling to California but for filming the activities, this would have been a legal relationship and a consensual one. In fact, I don't think Jane herself testified that there was anything not consensual about her relationship with Mr. Kelly at that juncture. Certainly, later on, she testifies that the relationship had abusive qualities to it, but specifically as to those Mann Act violations, I don't think her testimony suggested as much. And I want to point out, as it relates to faith, again, the court is aware of our position on the sufficiency of the evidence as it relates to those Mann Act violations and to the sufficiency of the evidence on the forced label offense. Taking that into account, it's our position that these offenses are isolated. They were not particularly aggravating in the sense of there was no minor involved. There was, in connection with the Mann Act violation with the trip to New York. I think that's in connection with the Racketeering Acts 12 and 14. Faith testimony reflects the defendant invited her to New York for his performances, and she accepted. And this Mann Act violation is predicated on her claim that the defendant exposed her to herpes. And Faith testimony, of course, is that she didn't actually contract genital herpes, but understood that, you know, this doesn't go, at least from the court's perspective, to whether or not the evidence was sufficient to sustain the charges, but is relevant in determining the seriousness of the offense. So I'm so confused by Faith and them herpes at this point, because J-Bo reiterated what I read off that goddamn transcript. I'm confused now. Maybe she allegedly contracted them at a later date. Maybe, I don't know. I'm confused. I'm so confused with Murphy's now. I figured out. And I would point out that Faith herself has not used the word victim. She has not called herself a victim, and she has denied that she was a victim. She has indicated that she made a choice. She regrets that choice, understandably, but that she herself does not see herself in that light, or at least she didn't when she testified on cross examination at trial. The government seeks to see defendants sentenced to what would really amount to a life sentence. African American men with diabetes, and Mr. Kelly has, do not live far into their 80s in prison. So we are talking about a life sentence for him. And it's our position that, again, the nature of and the circumstances of the offenses for which he does not face severe penalties do not justify a de facto sentence of life. The court is also obligated to look at the history and characteristics of the defendant as well. I will not belabor the point that the defendant is widely accepted as a musical genius and that he is has contributed to society in multiple ways in terms of his music, his generosity. As probation pointed out, he does have a history of being generous. He has made many contributions. He has supported his family in ways that sometimes seemingly not justified. But I do want to point out that Mr. Kelly, there are mitigating factors that relate to the fact that Mr. Kelly is a product of his childhood. His views, his attitudes towards sex were shaped by a long and significant history of sexual abuse that began when he was in grade school, in addition to a bevy of other childhood trauma. Probation posits that the child abuse is so long ago that it cannot be considered a strong mitigating factor. But that argument ignores the science about traumatic childhood. These events shape us, they change our brains, they make us who we are. And Mr. Kelly, like others in his household, were victims of horrific, protracted childhood sexual abuse by a sister and a landlord. Now, traumatic childhood isn't an excuse for criminal behavior. We are not suggesting it is, but it does make certain conduct understandable. The science explains that abuse and witnessing violence creates stress that often derails the development of the human brain and a healthy brain. And it is true, one of the speakers said here today, some people are very resilient to trauma and their own behavior is not impacted by it. Those people are blessed. But the science tells us that not everyone is so resilient, and Mr. Kelly is perhaps not as resilient as others. As the mitigation reports point out and our sentencing memorandum reflects, the defendant grew up in poverty. He was the very product of a single mother who eventually married. Wait a minute, who did eventually marry. He grew up in a highly chaotic home with domestic violence, substance abuse. He was surrounded by violence not only in his home but in his community. Himself was shot. He witnessed the terrible drowning of a childhood sweetheart that he was powerless to save. He had consistent issues with learning and literacy issues that extended to today and brings him to great pain and shame and bullying. And again, this is not to suggest that these mitigating factors are not that are forgiven by or that mitigating factors are an excuse for criminal conduct. We're not suggesting that in any way, shape, or form, but we are suggesting that they do help put a lens on certain behavior and allow the court to see it through that lens in a way that is not so dimensional, one dimensional. The government depicts Mr. Kelly as this mastermind who used his fame and fortune to prey on children. They've described him as calculated and cunning. And I think it's important to understand that Mr. Kelly's life from childhood up until even He was a big star, was very chaotic. He is not the calculating, cunning individual. He, yes, he was a superstar, but he lacked control of his environment. He did not have the skills to control his environment. He lacked the literary skills. He was exploited financially by and scores of people. He was surrounded by people that he entrusted to help keep his life on straight and narrow, and many of them exploited him and often felt powerless to impact that. I think it is important to know that Mr. Kelly has people who love him. There are people who support him. There are people who the government insists on calling victims still who love him, including his fiancee Joycelyn, who has stood by his side since his arrest. I know that there is a perception that Mr. Kelly has this control over people, but Miss Savage lives in Chicago. She visits him infrequently, and there is a real connection there. And she denies that she was ever a victim or that she is currently a victim. And the government doesn't get to decide that she is a victim. Mr. Kelly had love from prior employees who do not describe the circumstances under which they work in the same way that the government has set forth. So I think it's important that this court remember, and I know that I don't mean to tell the court how to do its job, but this case has been incredibly emotional. Mr. Kelly rejects that he is this monster. He is a multidimensional person. He is a flawed individual. He accepts that he is a flawed individual, but he is not the one dimensional monster that the government has portrayed or that the media has portrayed. That does not mean that he sits here without regrets. He does sit here with regrets, but he does not and cannot accept the characterizations entirely that the government has laid out. So at that, I will cede the floor to the government. And the judge says, "Thank you so much." All right, let me take another bite. I'm coming out with a minute. Yeah, a few more pages. Whew. Okay. The judge says, "Thank you so much." Prosecutor says, "Thank you, Your Honor." The judge says, "Ms. Geddes." Ms. Geddes says, "The government, of course, acknowledges that the defendants." The judge says, "Move the microphone a little bit closer to you if you would." All right. The court says, "Thank you." And the prosecutor says, "The government, of course, acknowledges that in the defense youth, he suffered hardships, very significant ones. But he also rose to become an R&B star with extraordinary resources at his disposal. Rather than use those resources for good or solely for good, he used them for to form an inner circle that operated to meet his every request and demand for decades. The defendant, with the assistance of his inner circle, enticed children to engage in sexual activity that they were too young to consent to. For decades, the defendant, with the assistance of his inner circle, video recorded children engaging in sexual activity. For decades, the defendant, with the assistance of his inner circle, exposed young women, young men, and children to an incurable sexually transmitted disease. And for decades, the defendant, with the assistance of his inner circle, exerted tactics of coercive control over many of these young women and children, making clear that he believed that they were his property. He promulgated rules. He dictated what they called him, what they wore, who they spoke to, what they spoke about, and who they looked at. He imposed penalties when he foresees that his rules were broken. He banished them to a room or bus, sometimes for days at a time. He coerced them. I'm sorry. He spanked them violently. He assaulted them with shoes, electrical cords, and other objects. He coerced them to write embarrassing letters, make videos of embarrassing conduct. He directed them to commit humiliating acts involving feces. He required them to have sex with other women and men they never even met and star in his homemade video recordings so that he could relieve this abuse in perpetuity. Put simply, for decades, the defendant, with the assistance of his inner circle, was a sexual predator. I want to speak for a moment about what ultimately happened before the government's investigation began. In the summer of 2017, the parents of two young women sought immediate assistance in reconnecting their daughters, one of whom testified powerfully before Your Honor as Jane. And by 2017, Jane was under the control of the defendant for almost 2 years. Later that same year, a few months later, in 2017, Geronda, another woman who testified powerfully at trial, spoke out against the defendant, publicly recounting for the first time the abuse that she suffered at the hands of the defendant. The following year, in 2018, Faith filed a civil lawsuit against the defendant, even after the defendant and his associates made clear to her the harm that would follow and did follow. And in 2019, that docuseries of Surviving R. Kelly aired. As a result of those brave women' public statements, each of them, Jane, Geronda, and Faith, were exposed to extensive retaliatory tactics, both directly by the defendant and his associates, as well as hundreds of the defendant's fans who seemingly blindly supported him. These young women did not ask to be abused by the defendant. These young women did not seek the notoriety that immediately followed their bravery in speaking out against him. They did not deserve the retaliation of the defendant and his inner circle, and they did not deserve to be vilified on social media. The intrusions on their privacy and the extraordinary harassment that many of them face and will likely continue to face. But because of those women and many others, including Stephanie, Sonia, Annie, Addie, Kate, Lewis, and Alex, and the defendant now, of course, stands convicted of a very serious crimes and the abandon with which the defendant committed those crimes have ended. The court heard today many of those women eloquently describe to you the extraordinary trauma that they suffered at the hands of the defendant and at trial. Your Honor heard the powerfully and extremely difficult testimony of many more, including Geronda and Jane, for whom I want to speak about just for a minute since they were not here today. Geronda told you and the jury that she was sexually abused by the defendant beginning at the age of 16, and that lasted for a period of 6 months. And she described, and I believe Your Honor will recall, when she read a journal entry that she wrote close in time to the abuse, about how one day the defendant walked in, saw that she was on her phone, and was upset with her and choked her until she passed out before he told her to give him oral sex, and they had sex. She broke down when she read the journal entry, remembering the trauma that the defendant caused her. Jane also testified properly over a period of days because the 4 years that she spent with the defendant, 4 years that began when she was 17 years old. The defendant knew she was 17 years old by August 2015 and yet continued to engage in sexual relationship with her, including in states like California where she was too young to consent to that sexual activity. And then the defendant exerted extraordinary control. She told the court how the defendant chastised her, spanked her every 2 or 3 days, and how the defendant made her have sex with other women when she did not want to, and even a man she never met. I'm sure Your Honor will recall the audio and recordings, video recordings that were so devastating. They were so devastating that the government played only small portions, and even then, I'm confident that neither the court nor, frankly, the jury will ever forget those snippets. On one, the defendant audibly spanked a young woman, instructing her to walk naked back and forth, repeating over and over derogatory comments about herself. On another, defendant threatened a young woman that people get murdered for shit like that. His words, that being that theft of a watch, and then commanded her to confine herself into a garage and not to make any phone calls other than to him or the studio, and to be ready when he wanted her to start in his next recording. And finally, Your Honor, saw a video of a young woman rubbing feces all over her body because the defendant told her to do it. The nature and the circumstances of these offenses, which the defendant has been convicted of, are simply extraordinarily serious, and notwithstanding the overwhelming evidence of his guilt, the defendant has not acknowledged any responsibility for his criminal conduct and continues to perpetrate a version of offense that is utterly belied by the evidence introduced at trial. It is not enough to say that he accepts. Who was this? What do you want, idiot? Ugh. Sit back and take notes, bitch. Okay, let me see. What was that? Perpetrated version of the offense that is utterly belied by the evidence introduced at trial. It is not enough to say that he accepts responsibility and then continue to perpetrate this narrative that he did nothing wrong, because it has shown no remorse or even acknowledged the crimes that he's committed. The government submits there is simply little reason to believe that the defendant would be deterred from committing similar crimes if he were given the opportunity to do so. The sentence that the government seeks, one in excess of 25 years, is not a life sentence. If Your Honor were to impose a sentence of simply 25 years, the defendant with good conduct time would be released when he is 73 years old. That is not life. Today, on behalf of those who the defendant sexually abused and otherwise harmed, on behalf of Aaliyah, Stephanie, Sonia, Geronda, Jane, and Faith, we ask the court to impose a sentence of imprisonment in excess of 25 years and the maximum fine, a fine of $250,000, a sentence that reflects the seriousness of his conduct, a sentence that would deter the defendant and others, including others in his position of power and with his wealth, from engaging in similar conduct again. Thank you. The judge says, thank you. And she says, Mr. Kelly, you have the right to speak if you wish to make a statement. If you do, I would just ask that we move the microphone back so it can be heard. And Ms. Bunjing said, Your Honor, Mr. Kelly will not be making a statement today. He does not have he does have pending cases, and I want the record to be clear about that. The judge says, I'll ask him if that's his wish. And R. Kelly says, Yes, Your Honor, that's my wish. And the judge says, All right, thank you so much. Sentencing another human being is probably the most difficult thing that a judge has to do. Taking into account that person's history and background, recognizing the general proposition that none of us is measured by the worst thing that we've ever done. Nevertheless, I am obligated to consider the statutory factors that are set out by Congress in 18 U.S.C. Section 3553A. I am also required to calculate the advisory guideline range and to consider the background and personal history of the defendant, as well as the nature and the circumstance of the offense. I will say, with respect to the calculation of the guidelines, the sentence that I impose today is a sentence that would have imposed regardless of the guideline calculations or any enhancements that might have been disputed. I will, because the statutory factors guide the court's sentence, I will lay out what those are. The sentence must reflect the seriousness of the crime. It has to promote respect for the law. It has to be fair and just. It must act as a deterrent, not just to the particular defendant in front of me, but to anybody else who would consider engaging in similar conduct. It has to protect the public from the future crimes by the defendant. It also needs to provide the defendant with any rehabilitation that he requires. I am also mindful of the need to avoid unwarranted sentencing disparities. I think it is safe to say, Mr. Kelly, that you are a person who had some great advantages. You had worldwide fame and celebrity, untold money. As your lawyer points out, your childhood was quite difficult, and I'm mindful of the suffering that you endured, including sexual abuse at a young age. It is something I taken into account. Perhaps some of the experiences explain your behavior. As we saw in court today, there are countless people who had difficult childhoods and those experiences, and they do not commit crimes of which you have been convicted, but it may explain, at least in part, what led to this behavior. Even if it Even if it is a form of an explanation, it is most surely a not an excuse because, after all, these are not the crimes of an impulsive person, someone who can't control himself because of a sex addiction. I mean, although sex was certainly a weapon that you use, this case is not about sex. It's about violence and cruelty, the define and control. These are not isolated acts of otherwise law abiding person. They are not aberrations. These crimes are calculated and carefully planned and executed with regularly for almost 25 years. Using your status as a celebrity and using the enterprise. And it was an enterprise that you developed with your circle of employees and entourage. You had a system in place that lured, excuse me, young people into your orbit, and then you took over their lives. You preyed on your ready supply of adoring fans, targeting them at your concerts and having one of your enablers bring them to you, having your minions, oh Lord, having your minions troll for young people at the mall, at your local McDonald's, handing out your phone number for the opportunity to meet R. Kelly. Like all young people, as we heard today, your victims had dreams and goals. Many were just the ordinary dreams of high school students. They were in the choir. They played on the varsity team. They were doing what children in high school ought to be doing. Many of them dream of being a singer, having success in the music business, and other people just wanted to be around a celebrity. And you took advantage of those hopes and dreams. Come to my hotel room and audition for me. I would like to teach you some techniques. What are you willing to do for a music career? I'll listen to your friends sing if I can get to know you. You told these children that in order to succeed, they had to leave school. I want to say a word about these enablers, the managers, the personal assistants, the engineers, everybody else who was around you. The evidence in the trial proved overwhelmingly that they were part of the structure that enabled you to do what you did because they not only brought these young people to you, they enforced your many rules. They guarded the victims when you punished them. They monitored their activities, their internet use, conversations. They stood guard when you directed them that they would be isolated, and they reported any violations of your rules. There is one audio tape in which two of your circle were there backing you up while you accused a 20-year-old of stealing a watch, threatened that you would track her down, and then ordered her to perform in one of your humiliating videotapes. Demetrius Smith and Larry Hood were in your apartment when you led a group of teenagers. Mr. Hood testified that they were Aaliyah's little friends into your room and had sex with them. And then there's Aaliyah herself, 12 years old when you first met her. Angela saw you perform oral sex on her when she was 13 or 14. Mr. Smith knew what you were doing, but when you thought she was pregnant and thought you would be caught for what you had been doing, he and your other handlers helped to bribe somebody to get this child a fake ID so that you could marry her because you wanted to cover up that you had been having sex with a young girl. They wanted to protect you and your career, and they helped you, and the victim didn't matter. There are countless other examples of employees who stood by or enabled your behavior. They heard you beating these victims. They knew that you were holding them in a room or on a bus. I don't know why all these people turn a blind eye whether there was an exception to every standard of human decency just because you were famous. Did they agree with you as we heard at trial? Did you do trial that you can do whatever you want because you fancy yourself a genius who should be allowed to do whatever I want because of what I give to this world? Maybe it's just because normal, though, maybe it's just became normal to those people, normal that a man in his 40s and 50s was holding teenagers in his house, trapped in a bus, having sex with them, beating them, imposing rules. Even in this courtroom, it became normal to refer to these victims as your living girlfriends or female guests. There's much, much more that could be said about people who excused this and tolerated for all these years. But these people are not before me for sentencing today. You were at the top of this organization, and it was you who used this organization to find your victims. The evidence established that you raped them, beat them. One witness said you beat her until she broke, separated them from their families, made them have sex with groups of people, filmed them, made them write letters with lies about their families, that they were that they stole things, forced them to do unspeakable things, which you also filmed and saddled them with an incurable disease. One of the witnesses described these victims as zombies. Lewis described an instance where you snapped your fingers and a young, very thin, naked girl crawled out from under a boxing ring. I will never forget that, and ordered her to perform oral sex on you and then on Lewis. There just so many examples in this trial of indifference to human suffering or sheer brutality. I could not count them all. I think it's safe to say that even the most seasoned investigator will not soon forget the searing evidence about the horrors your victims endured. All right, 1 minute, y'all. Couple more pages to go. Couple more. Oh Lord, why is this? Somebody block this weirdo. Oh my gosh. I mean, little weirdo boy, I don't know if medicine is what you need. Somebody beat you the fuck up. Somebody, I don't know what you need, but you a crazy motherfucker. But you got the right motherfucking one. You better be glad I got a few more pages and I can entertain your motherfucking ass. Because I told you what I'm gonna do to your motherfucking ass. You like to harass bitches? I'm gonna harass your motherfucking ass. I still got your shit. And I promise you, I have sent so many motherfuckers at your goddamn ass, you have to move from wherever the fuck you are with your crazy ass. Get your ass on some motherfucking well. I'm not Mr. Neat. I will have your motherfucking ass all fucked up. Get your ass on somewhere, your stupid ass. Take your motherfucking medicine and take your ass to sleep some fucking well. You simple motherfucker. You crazy. Stalking motherfucking people. Get your ass up. It's fucking crazy. Somebody need to beat you the fuck up. I bet you somebody get hold of you and beat that fucking crazy out your motherfucking ass. You get your ass off YouTube. Your stupid ass. Give a fuck about you being young. Damn crackhead ass motherfucker. I should kick the motherfucker's ass that enabled your ass to be in this motherfucking sector with that stupid shit with your dumb ass. People the fuck alone. I'm glad I did look. Cause I was finna, boy, I was, I was finna unleash some shit on some motherfuckers who I thought it was. Get your ass out of here. Yeah, that's that old crazy motherfucking Tim Snow or Don Snow, whatever the fuck that idiot name is. He's a crazy bitch. Come on, because I want to hear all this shit. They talking about she already had a mind made, all this old crazy shit. It don't be number one. Well, there's a couple people. But it don't be number one person be yelling out all this old stupid shit around here. Never be factual. Ugh. Stand that motherfucker. Let's see. Okay, your own words and actions captured so chillingly on those videotapes put the lie to the claim that you are the victim here. These victims were disposable to you. As one of your victims said today, no price was too high for someone else to pay for your happiness, and you left them in your wake a trial of broken lives, and at such a vulnerable time in most of their lives. They had no experience with what it meant to have a loving relationship with someone. You taught them that love is enslavement. and violence and humiliation, and that they were not worthy of simple respect and dignity. We heard today from some of your victims, and it took courage to testify about these intensely personal things and the depravity that they suffered at your hands. They still bear those scars, emotional and physical, and they probably always will. Some wonder why no one stopped you, and even sadder, some still seem to blame themselves as if a teenager were responsible for stopping a celebrity of your age, or if a teenager were somehow responsible to resist your hold over them. They have no such responsibility. Despite what they endured at your hands, however, they afforded you a measure of grace and forgiveness, and perhaps you will be able to reflect on just how powerful that that is, and draw strength from it in the years to come. I listed at the beginning of the factors that guide a court in sentencing, as well as the defendant's history and characteristics. I want to speak specifically to those factors and how they apply to the analysis in this case. Cap, the seriousness of the crime. This is a case involving serial rape and sexual abuse over a very long period of time, and there are few crimes more serious than that. The sentence must promote a respect for the law, and in this case, it must demonstrate the conduct that is egregious that will be punished appropriately. It must be fair and just, and it must act as a deterrent, first to Robert Kelly. There were times in your life where many people might have taken a second look at what they were doing. There was an instance when you were acquitted after a trial, but it seems the only thing you took from that experience was to try to figure out ways to hem your victims in in either with non-disclosure agreements or making humiliating tapes. And I also considered the evidence of the mitigation reports. You did not have you did not speak with the psychologist, but in my view, your efforts to explain away your conduct and some things that were just demonstratively demonstratively why I can get that word out, demonstratively false, tells me that you will not be deterred. This sentence must act as that deterrent. It is also it also must deter other people, any important person or celebrity, a powerful person who thinks like you that he or she is above the law because of who that person is. And the public has to be protected. The public has to be protected from behavior like this. So, taking into account all of those factors, it's my conclusion that the appropriate sentence to count one is 360 months. Count four and five, 20 years on each count. Counts two, six, and eight, 10 years on each count. And counts three, seven, and nine are also 20 years. All of these sentences will run concurrently. There is 5 years of supervised release. I'm going to lay out the conditions for that. They are rather long. I will do that in a minute. There is $100 special assessment for each of the 9 counts of the indictment. Uh, Prosecutor says, Your Honor. The court says, I'm not quite done, but go ahead. Did I miss something? Prosecutor says, Yes, just one thing. I apologize for interrupting. The statutory maximum on racketeering is 240 months, and therefore I think in order to impose a sentence that I think Your Honor seeks to impose, it would be 240 months on count one, the racketeering act, the racketeering count, and then an additional 10 years to be served on one of the other counts to be served consecutively. Court, okay, wait a minute, let me look at some. She said 240 months there. Okay. Okay, just consecutively, then consecutive 10 will be on count two. Hold for just a minute. Then the prosecutor said, Your Honor, I also may have misspoken. Let me correct. The court said, I don't think that was in anyone's submission. So at least in terms of that, that analysis. I just want to make sure that that's correct. The prosecutor says, I think that the probation department just explained to me, and I think they're correct. In racketeering, the penalty is 20 years unless one of the predicates is life. And they just reminded me that we do have a lifetime maximum predicates, and therefore the judge says yes. And the prosecutor says, I believe your honor is correct. I apologize. Court says that's okay. No, no, no. It's complicated. So me just let's just make sure that the record is clear that the sentence on count one in those circumstances is 360 months. I'm going to repeat what the other ones were just to make clear because it's my intentions that those run concurrently. And so that would be a 20-year sentence on count 3, 4, 5, 7, and 9. Concurrent 10-year sentence of two of counts 2, 6, and 8. I believe that covers everything. As I said, there is a 5 year, or there are 5 year of supervised release and $100 of special assessment on each of the 9 counts. I also considered the parties' submissions on the questions of a fine, and I considered the statutory factors that have to be evaluated when imposing a fine. Under these circumstances, a fine is must be imposed unless the defendant has established that he can't pay a fine currently or in the future. And under these circumstances, I think the evidence demonstrates that this defendant is capable of paying the fine, and that fine that I impose is $100,000. And as I said, I will get into those conditions of supervised release momentarily. There is also a question of restitution, and at this point, I think the record is incomplete on the subject of restitution. And so, what I'm going to do is, under the statute, adjourn to a date in September. I'm going to have the parties confer and submit a briefing schedule to me on when you can get your information in. The date that we determined for that restitution hearing is September 28th, which is on a Wednesday. And that's why don't we do that at 11 o'clock? I don't know if there's been some submissions on this from both sides, but we're just not in a position to make that decision today. Now, the conditions of supervised release are laid out in the probation department sentencing recommendations. I'm required to put those on record, and I will do that. The defendant has to comply with any applicable state or federal sex offender registration requirement as the probation department instructs, or the Bureau of Prisons or registrations agency in the state where he's working or residing. The defendant has to participate in a mental health treatment program, which may include participation in a treatment for sexual disorder, a approved or by probation, and the defendant must contribute to the cost of those services and securing any applicable third-party payment. He has to disclose all financial information to the probation department so that they can assess his ability to pay. He will also have to participate if there is a treatment program for sexual disorder in any polygraph examinations or testing so that they can get the necessary information for risk management and treatment. Now, just a note on that probation specifies that Mr. Kelly is eligible for a treatment in the Bureau of Prisons. And if you don't have to answer me now, but if the defendant agrees to do that, I can make that a part of the recommendation. The defendant must not associate or have any contact with any of the convicted sex offenders unless it's in a therapeutic session setting with probation's permission. You must not associate with children under the age of 18 unless a responsible adult is present and he has previous approval from the probation department. That approval does not apply when there are contacts of which he doesn't know in advance, or if the children have parents or guardians, or if they are incidental contacts in a public setting. If there are any of those non pre approved contacts with children, it must be reported to the probation department as soon as practical, but no later than 12 hours. Whenever he begins supervision, the defendant has to provide probation with the identity and contact information of any family members and family members and friends who have children under the age of 18 if he expects to have routine contact with them, so that the probation can contact these parents and approve the routine family and social interactions. If the defendant were to live with somebody who has minor children, he has to inform them of his criminal history and will have to notify them that prohibited from prohibited from association with children under 18 without presence of a responsible adult. The defendant has to report to the probation department any and all electric communication services accounts that are used for user communication. This includes, but is not limited to, email, social media, core and cloud storage accounts. He must provide any account identifier and password for each account and report the creation of any new accounts and changes in identifiers or passwords, whether he suspended or deleted an account within 5 days of any of these actions. Failure to abide by these conditions might be grounds for revocation of his release. Also, probation must have access to the search of any of his accounts only when reasonable suspicion exists that he's violated a condition of his supervision and accounts and contain evidence of this violation. Failure to submit to that kind of search might be grounds for a revocation of release. There's also a search condition that requires that the defendant to submit to search of his person, property, house, vehicle, papers, computers, and any other electronic communications or data storage devices or an office. The search will be via United States probation officer. The defendant has to warn any other occupants that the premises might be subject to searches. Failure to submit these searches may be grounds for revocation of release. Any officer may search pursuant to his condition only when there is a reasonable suspicion that a defendant has violated a condition of his supervision and that the area search contains evidence of the violation. The search also has to be conducted at a reasonable time in a reasonable way. The next condition requires that the defendant is not to use a computer or any other internet capable device or electronic device to access any visual depiction, and that's a pornograph, film, video, picture, computer or computer generated image or picture of a sexually explicit conduct. Do not use a computer, internet device, or any other electronic device or view image of a naked children. The judge, okay, he may not use his computer to view sexually explicit conduct or view depictions of naked children stored on related computer media like CDs, DVDs, and he may not communicate by computer with any person or group that promotes the sexual abuse of children. The defendant must cooperate with the probation officer's computer internet management and monitoring program, and that cooperation includes, but is not limited to, identifying any computer systems, internet capable devices, or any electronic media that's capable of data storage that defendant has access to. And this will include allowing probation to examine the device and install monitoring software on the device at the defendant's expense. The software is authorized to capture and analyze all data that is processed by or contained on the device, including the geolocation of the device. The probation office and geo is a geographical location. That's when y'all see those maps and stuff that be on Google. When you click on it, that's the geo. Okay, the probation office may access the device or the data captured on it by monitoring software at any time without suspicion that defendant has violated the conditions of supervision. It may be that the defendant is limited to possession only one personal internet capable device so that probation can manage and monitor the device effectively. The defendant must also permit seizure and removal of computer systems, internet capable devices, and any electronic media capable of data storage for further analysis by law enforcement or probation officer based on reasonable suspicion that in violation of conduct or suspicion of unlawful conduct by the defendant has or it is about to occur. Failure to comply with any of these terms may result in serious revocation of release, and the defendant must inform all parties that access monitored device that is subject to the terms of this provision. The defendant must refrain. He must not contact the victims of any of the victims of the offenses in this case. That means he can't attempt to meet them, communicate with them by phone, email, the internet, or through a third party without the knowledge and permission of probation. Upon request, the defendant must provide the probation department with full disclosure of his financial records, including commingled income, expenses, assets, and liabilities to include yearly income tax returns, with the exception of those accounts that are noted in the pre-sentence report. The defendant might not maintain nor open any additional individual or joint checking savings or other financial account for business personal purposes without probation's approval, and he must cooperate with probation in investigating his financial dealings and provide truthful monthly statements of income and expenses. And he will also cooperate and sign any authorization for releases to permit probation to get access to their financial information. The restitution topic will resolve at the next hearing, but if restitution is imposed, the defendant is going to have to comply with it. One thing I neglected to do was to institute a payment schedule for the fine. Does probation have a suggestion about that? Um, Mr. Canopoulos said, no, Your Honor. Typically, the schedule is 25 cents per quarter, $25 per quarter while in custody, and 10% of the gross monthly income while on supervised release. The judge says, all right, those are the terms that I will impose for the fine. Is there anything else that I have neglected to do? The prosecutor says, other than advise the defendant of his right to appeal. The judge said, oh, I will do that next, but anything else? Yes. And Mr. Nicholas said, Your Honor, the special assessments in this case. The judge says, I think I did it. And Mr. Nicholas says, sorry. The judge says, the $100 per is the $900. And Mr. Nicholas says, sorry. Judge says, no, no, no. It's always good to be reminded. I did do that. So, is there anything else besides the notification of the right to appeal? Prosecutor says, no, Your Honor. Judge says, anything from the defense? J-Bo says, no, Your Honor. The judge says, all right. I do want to notify you that Mr. Kelly, I do want to notify you, Mr. Kelly, of your right to appeal. Any notice of appeal has to be filed within 14 days of the filing of the entry of the judgment or within 14 days of the filing of the notice of appeal by the government. If you request it, the clerk will prepare and file a notice of appeal on your behalf. If you can't afford to pay the cost of an appeal or for an appellate lawyer, you have the rights to appeal for leave or to appeal in form of papyrus. That means that you can apply to have the court waive the filing fee. On appeal, you may also apply for a court-appointed lawyer. Are there any are there any other matters to resolve? Ms. Cruz Melendez, one moment, Your Honor. Judge says, sure. The prosecutor says, Your Honor, with respects to count 2 through 9, according to as set forth in paragraph 301 of the PSR, the Justice for Victims of Trafficking Act of 2015 also requires the court to impose a $5,000 on any non-indigent person convicted of the crimes set forth in 2 through 9. So we ask that Your Honor also impose that assessment. The judge said, is that $5,000 per victim? And prosecutor says, I think it's just a single $5 grand. The judge say, it's a single 5 grand, and the prosecutor says on each count though, correct? And the judge says, is it for each count? Prosecutor said yes, counts 2 through 9. Judge says so that is, and then the prosecutor said 8 through 9. And the judge says, and I just want to get the defendant's position on that. Do you take any positions on that? Jabo said, probably. The judge says, that's all right. Do you want to take a minute to think about it? Jabo said, yes. And the judge says, it's just the Justice for Victims of Trafficking Act of 2015, and it just requires that the court assesses $5,000, as the government says, on any non-indigent person or entity convicted of an offense. I think it's under Chapter 77. Is that right? Chapter 117, Chapter 109A, Chapter 110. And that, correct me if I'm wrong, but I think the statutory provision is 18 U.S.C. 3014. Just to be clear, it's my understanding that this is not payable under the defendant until the defendant has paid fines and orders of restitution. Jabo says, Judge, if the exception is indigency, I'm sorry, he hasn't been declared indigent yet. So if it's statutory and that's the only exception, then I don't know that we have an alternative argument to make. Judge says, all right, I do impose that $5,000 on counts 2 through 9. Is that right? If 40 grand? And the prosecutor said, yeah, 40 grand. Okay, and the prosecutor said yes, and the court says, I think it is so. I think it is, so that a amount of $40,000 be. But correct me if I'm wrong. I don't think I impose a payment schedule on that one just by terms of a statute. It says it's not payable until he has satisfied all other things. And Mr. Kanakis says, Your Honor, I don't believe you need to impose a payment schedule for that. Judge says, okay, all right. Oh, so that is that pursuant to 18 USC section 3014, I impose that statutory amount on each count, counts 2 through 9. Anything else? Um, prosecutor says, not from the government. Jabo says, not from the defense. The judge says, all right, everybody, thank you so much. And that be it. Let me come around there, y'all. Woo! Child. Y'all in here fighting this morning. I'll be so scared to read these. When I see S nice in here and the hell, child, just, I don't want to read these. What's up, Cool BJ? The hell in the building. I got Mark King K. I got Michelle. That's it. That's all earlier. Miss Sheena, two, not three, but two. Hey, Shay Dalton. Yes, please hit that lock a button. I'll lock you to lock a button. So, well, we dispel a lot of rumors. Lots of rumors. So she didn't say her mind was made up. She didn't say none of that stuff. Mm. Yeah, I got about 11 more minutes. Cool, BJ. Cool, BJ. Yes. Got that down in the book. What? So he didn't have it. So no one came to speak. Like I said, it's not because probably because no one didn't want to speak. Because I know a lot of people wanted to speak, what have you. probably, probably strategic. So it's nothing to read into. And a lot of times when you see things that goes on in these cases that seems weird, think strategy first. Don't think automatically, oh, something nefarious going on, or oh, something bad, or oh, his friends done bailed on him, oh, the prosecutor's doing something. Don't think that. Think strategy first, or whatever. If I get to it first, if I can kind of tell what it is, I'll tell you what I think. Because they are very careful, what they're saying. You just got to keep that in mind. It's a pretty one. Yeah, it's you know, I would imagine that absent with all of the allegations that happen in these relationships, you gotta think these are younger people, and even absent of that, right? Then you got some people that you see that was full grown women that agreed to be in a relationship with somebody that had multiple partners. And then there you go, developing feelings for somebody that got multiple partners and a superstar. I can imagine. Now, I think the girl that, what's her name, Sonya, I heard people saying, why was she allowed to testify, or not testify, give her statement if they didn't believe, her or whatever. Anybody that wanted to give, even if they wasn't even in the case, as you see, anybody that wanted to give an impact statement, they could have, you know, what I'm saying, with the of course, it based on what the judge, but pretty much I've never seen a situation where the judge wasn't allowed or whatever. But I always keep in mind the judge makes the rules for a courtroom, and she goes by what's primary law, which under primary law is the procedures, right? So, um, let me see what else, what I can point out, what we learned from that. So, just important is keep in mind, please keep in mind that you can't start crossing over the people in New York, the anybody in New York with anybody in Chicago. These are two separate cases with two separate types of elements. Okay? So the testimonies will be different. You may or may not see people testifying from New York. You might see some uncharged acts or whatever come to testify for the same purposes as they did in New York. I mean, it all depends, like I said, on the elements. So let me see. Well, all those are videotapes and things of that nature. So those uncharged acts in New York, a lot of them testified to show the patterns, to show how the the managers and the people, how they just tried to cement the firm up to patent up that enterprise narrative, right? Okay. And then the videotapings and the disease and stuff like that. if there was some people in New York that he videotaped, that's a good chance they were testifying in Illinois, because that would be directly related to his charges. That would be relevant. Um, what else? Good. The hell, you live somewhere in the South? Cause I thought, cause I think well, I don't think it go by that, because in Georgia they have White Castle. We have crystals here. Oh, them crystal burgers. I can remember coming from the club. Oh, and crystals was open. Mm, 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 mm. Crystals, crystals, crystals. Them little burgers with that little soft bread on. Hey, that cheese. And mine have to be made special because I don't like mustard. Mm-mm. So I get I get the ketchup, onions on there, on them little burgers. Mm, 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 mm. Yeah, we don't have White Castle. We got crystals here where I am. I know it's White Castles in Georgia. Cause before, it's so crazy. We used to run the part. We used to party up in Georgia in the late '80s and early '90s. That's before I met the Walker husband, and his stepfather. I'm not stepfather. His father is coincidentally ended up being from that area too, the parts of Georgia. And we used to go to Georgia every day. At that time, I used to live on the north side, right? The north side is close to the Georgia line. Hmm. And baby, we used to partay. Like, well, I tell you, but we wasn't really partying. I mean, you know what we was doing, really. Going to see some boys. I learned, and the guy that I was dating in Georgia, he's the one that taught me how to drive. Hmm. He's the one that taught me how to drive. Do you know that I was I was married the same year. I was married and divorced the same year I learned how to drive. The first time. Mm, married and divorced. Surely did. I was married and divorced. Hold on, check this out. Now I'm gonna show you this crazy ass timeline. I learned how to drive. I was married and divorced. I met my child's father towards the end of that year. The next year I got pregnant. Hold on, wait a minute. Hold on. I got pregnant. Had her the next year. Yeah, I got pregnant. Had her the next year. Had her the next year. Met the Walker husband that same year. Married him the year after that. Yes, honey. Mm-hmm. I sure it was. I sure did. Crazy, right? Child. I keep it together. Yeah. I had all the popular. Check this out. I would have had y'all check this out right here. I would have had all the popular last names, right? I'd have been a Jones, Walker, I'd have been a Brown, I'd have been a Green. Yeah. I'm giving you the popular last names. Yeah. And that's some shit. I'd have been all those different names. More than that, really. That's correct, Roy. What is y'all doing? Oh my gosh. Child, what the hell? And S Nice is on the scene. Mm-mm. What's a pink slip? What is a pink slip? Is that a drink? A strip club? Oh gosh, I don't know about that. Where's the pink slip at? Let me tell you about my motherfucking sheltered ass, as JoJo says. And it takes my friend. I think I'm still. I'm some kind of way. Oh yeah, I got to put those this week. I'm gonna put those two lives back up. I got to do a live and a live. I'm put those two lives back up. That one that Debosky was on before he got, and then the other one I got to re-edit. So I'm gonna do those this week. But listen, so I was in Atlanta, and my friend that's she not she sounds like a white woman, but she's not uppity or anything like that, right? But her family, her family, what it is, right? So everybody know that I don't have no sense of direction. I don't know where I be going. I don't be all in the whole bunch of bullshit, right? Just not like just wasn't raised out there like that, right? So my friend Tim, the one that made that song, talking about if I was prosecuting R. Kelly and shit, the one that used to come on the lives and stuff like that, the answer, the fuck with me or whatever, answer questions and stuff. So I was on the phone with him, and I told him I was in Atlanta. So he told, and I was in a room full of people. I don't know shit about no Atlanta. He told me, he said, "And tell somebody to take you to Magic City." So now I'm in there with my friend's parents, her dad, her stepmom. They're the ladies, her auntie, all them older people, you know, and they are they're not snooty, but you know what I'm saying. And I was like, I was excited. I was like, "Hey, can y'all take me to Magic City?" When I tell you that I promise you, I probably had this on a call somewhere. I promise you, when those people started looking at me and people was pushing their glasses down and shit like that, he on the phone laughing. He always do shit like that to me. He done none of that shit like that in front of JoJo. Like say all kind of ridiculous shit. Just for shock value to embarrass me and stuff like that. See that I told you that's the set of friends, because I got different sets that get me in front of people and ask me do I have drawers on and shit like that. Just to embarrass me. Right. So I'm asking people to take me to damn Magic City. People started looking at me all crazy. He on there laughing. And I was like, what did you tell? He talking about Magic City is a damn strip club. I was like, hell no. Hell no. Magic City. Yes. You probably, honey, I don't know where I be going. Mm-mm. I get lost coming home. I go right past the entry, the one I like to take. Then I have to go up a ways and turn around. Yeah, that boy had been play that joke on me, and those people was in there looking at me. They was pulling their glasses down. I'm talking about other, professors. I wasn't a professor then, but professors and shit like that, retired people. Yeah, they always do me like that. They will embarrass my ass. They will embarrass my ass. They don't give a damn. Cause see, I've never been the one that act like I'm so uppity and better than somebody and stuff like that. I don't give a damn. Cause see, here we're like the pot. Let me tell you something. The politicians here, the people that's in city and state offices, whatever, honey. When they go out, you can find them in the whole. It's not a hole in the walls. It probably a hole in the walls to a lot of you people, but they're not in the upper classy clubs. We really don't have any. I mean, these are they you find their ass in the side of the road clubs and shit like that. In line at the soul food places and shit like that. They ain't nowhere to eat no goddamn. Hell, they getting drunk and every goddamn thing else. We regular folks out there. We don't give a damn about no paperwork and people in office and shit like that. I don't give a damn about that shit. The newsman and shit. Let me tell you, one news. Let me okay. It's well Tim Deegan and his wife. Okay, let me tell you how they got together. These are newscasters, right? On our local news. She was married to this dude named Dan. He was a newscaster too. Tim is the weatherman here. She started fucking around with him, the weatherman. They got caught in a car one day, making out. They kept their job, but that's awkward as hell. So for a minute until I think he went to one of those like WGN, one of those Holy Ghost channels or whatever. But all three of them was working together. Him and her got a divorce, and she started seeing and then eventually married Tim Deegan. She she ended up getting cancer. I think the cancer she had cancer, and I don't know if it returned or whatever. But people were so mad because the dude that she was first married to was such a good guy. They were saying all kind of cruel shit like, "Well, that's what she get for cheating on him for the cancer," all kind of stuff like that. But yeah, mm-hmm. Tim goddamn Deegan, yep. Tim Deegan used to baby. He was a looker, honey. He was a weatherman. All on. Well, we got all kind of shit going on. The white guy that pulled my zipper down on my dress. I told you I done had all kind of shit happen to me. That sexual harassment. His ass was he used to do a sports show. Yeah, he used to do a sports show. And they was whew, somebody told I didn't even tell. I didn't tell on him. All I said when we was walking out, I was like, please zip my dress back up. My little black dress. I said, please zip it back up. And that next day when I came into work, they rushed me into the office. They asked me if I wanted to file a complaint on him. Was I okay? But I was like, yes, I'm okay. And he was doing a sports show. Sure was. What are y'all talking about? It's not. Wait a minute. Is it who all don't get along? Is it S Nice, the Hell, and Parker Gang? So what's the three of y'all being there going to fuck off on each other? Which one? Which I'm trying to figure out which one of y'all. Cause don't be S Nice be calling for the hell. The hell where you at? Where you at? Okay. I be reading some of the comments behind. I just oh, that's chat business. I don't get in the chat business. Mm-mm. I can't believe people be mad at me because I don't take sides or get into business. And shit. I'm not getting into business. That shit don't have nothing to do with me. I'm not picking no side on no under this argument shit. None of that. It's, I'm okay. I ain't got to follow behind nobody. I don't need no leader. I love progress. Progress is so goddamn funny. Oh my gosh. I love me some progress. Progress is funny as hell. Progress is funny as hell, y'all. He be trying to learn this stuff. See, it's don't let everybody fool you because a lot of these people, don't have the fundamentals of what the fuck is going on. You know what I'm saying? All they know is okay, this happened in the case, right? But they don't know the fundamentals. Don't have these people fool thinking, oh, they so smart because they know what happened in the case, whatever. Do you know the fundamentals? How this happened? How it what's the legal process of it? That's what we got to deal with. Y'all fine. y'all give me life, honey. Y'all give me life. Y'all crack me up. Well, I ain't gonna hold y'all. Y'all always hanging on in here with me. Always hanging on in here with me. I sure do appreciate each and every one of you. You got people opposing, with opposing views. And that's how we have a good conversation and a good chat. Yup. I don't know why I'm so sleepy. That's all Georgia and I did today was just sleep. It's like, are you serious? Yep, make sure y'all do all those flashing things on your screen. Please do. And and shouts out to Skylar. She is really laying that damn shit out there. That legal process and stuff, bringing it to her people. That's what's up. She is, giving the right information. That's what we got to start. Got to be consistent on that shit. Can't be just talking just to talk. Get that wrong information. Because I'm not going. I'm not going. I'm get. I'm getting the right information as best I know how. Not gonna come up there with that bullskate. You got people that just lie for no reason, child. Man, gonna make you start. Well, I'm gonna get out of here before you do. Before you do, child. Before you do. Well, all right, y'all, honey. Thanks again to the panelists, the host, the hostess, and the guests, and everybody else. Make sure you love one another, love yourself, and do something good for someone else. And until the next live, y'all have a blessed holidays. I love y'all. Oh, honey, I appreciate y'all so much. Y'all don't give me no trouble, child. I love it. Ooh. Oh boy, got another one in the book. Happy 4th. Bye, y'all. Be safe.